Ikaw nung malagputan. Yeah. Sorry.
Kumar. Yes. Matter is posted to. Matter is posted to.
The last page is 10 minutes. Then the application is filed seeking the information regarding the criminal cases pending against the petitioner.
Why it is posted to 10th?
The last one is Friday.
Why it is posted to on 10th?
Instructions.
Why you have not objected saying that there is an urgency, it has to be listed on Monday?
We will inform that matter is posted today. We are receiving an SMS regarding this posted at 10 minutes.
Tomorrow.
2023 transport is also transport matter. The not registering our vehicle. So when random vehicle without registration, it's going to heavy fines and costs also.
What is urgency?
We have to apply this.
Tomorrow.
Orders dated on the 12th of October.
Orders?
Dated on 12th of October by matters settled by the withdrawal order for dictation.
Yes, it will be verified. Give it this thing. What is urgency now? So what is urgency? Just before elections, what is urgency so far as the rowdy sheets case are concerned? Do you mean that this court is going to grant any order so far as those cases are concerned? No. What is urgency? 2017 matter. What is now urgency after 6 years? No. No. Threat of accused. So what is that relief you want? To file it, it will be listed. No, she is already mentioned and refused. Yes. Yes. She's already made a mention. I said no. Yes.
Weight-wise mentions. Page number 1, item number 1 to 20.
Item number? Item number? Item number?
30.
No. It's a motion case. Where is the question of you are filing additional papers? Having filed yesterday the matter, it is listed today. Friday when you filed a case, it is listed today. Why you have not filed all additional papers, whatever required along with the writ petition at the time of filing? Therefore, I will dismiss on that ground itself. Yes. You wait till your turn comes.
Page number 2, item number 21 to 32. Page number 3, item number 33 to 43. Page number 4, item number 44 to 60. Item number 59.
Why?
Counter.
Coming for counter of
Yes.
59. Coming for counter of whom? Huh? Additional AG? So what? Have they filed any counter affidavit? You are repeating additional AG office. Why you have not filed counter? Election code to counter gives సంబంధం అండి. తలనొప్పి లేస్తే మోకాలకు జాన్ బాంబు పెట్టినట్టుంది మీకు అంత ఆర్గ్యుమెంట్. So when the matter is 2021, it is not the matter pertaining to yes. Number of times the case was adjourned for filing of counter affidavit. It's a matter pertaining to with regard to GOMS number 86. Yes. Number of times the matter being granted adjournment. Have you informed other side? You wait till the matter reaches in the presence of the other side counsel. You make a request. Have you informed other side? Yes, at the request of the Government Assistant Additional Advocate General. This is case for filing of the counter affidavit on 28/11. Item number? Forty-two. Yes. You are appointing? This is admission matter, contempt admission matter. Why? Why it has to be taken up after 2 weeks? Who requested? Item number 43 is what is that matter? Have you informed the petitioner counsel? Huh? Will be Gardandi. Have you informed or not? No, when it reaches, you make a mention. Yes. No, when it matter reaches, you make a mention.
Page number 5, item number 61 to 73.
Yes. These matters earlier also you have taken time.
Senior counsel Mr. B. Bakami is appealing this matter, but his authorization requested for 15th or 16th for any day.
Yes, at the request of the land counsel for the petitioners. This case on 4/12.
Page number 6, item number 74 to 92.
Have you informed other side in this matter? Chandrasen officers. Yes, yes.
Page number 7, item number 93 to 112. Page number 8, item number 113 to 131. Page number 9, item number 132 to 139. Page number 10, item number 130 to 151.
Item number?
145.
Yes.
This is last occasion, City Council, this had updated this matter with us. In the last occasion, City Council had updated for this. And in the last occasion, it was understood that the matter should be taken up for hearing. Let's request lordships to have this matter required to be 30 or 230 minutes subject to your lordship's convenience.
What do you say?
And let's in fact, the scenario is here. Senior has come for this matter minutes.
Days ago.
230?
Yes, otherwise, the lordship may grant us some liberty. Senior is always doing minutes to report.
Even before making a request and having seen the cause list, where is the question of senior is on the way?
It was specifically posted.
Yes, but it is listed in the cause list, but how can we advance when other side is objecting for the advancement of the case?
In fact, in the last occasion,
No, let it be reached in the usual course. We'll see. Yes. Because when other side is objecting, how can I advance the case? Yes. When he is ready, you inform the senior counsel. He said he is not ready for today. He requesting for some time.
I'll take it.
Yes.
Item number 1, Mr. Nilesh.
Yes. What happened?
Sending the notice of.
Yes, what is it? It is release of the vehicle in a offense involved in excess. The direction was only to the deputy commissioner. Then why you made others as unnecessary as a parties? Direction issued to whom? Who is the competent authority to release the vehicle? Then why you made others as a party respondents to the contempt case?
Point 3 is holding the vehicle. Who is the one who has to be provided?
Ultimately, 2 is the competent authority to release the vehicle. 3 is only the custody of the vehicle. Once 2 passes an order, 3 automatically releases the vehicle. Why you made other 1 as a party and 3 as a party to contempt case? What is that formal party in contempt? I don't know. What is formal party in the contempt? Contempt is contempt. Who committed contempt? They are liable for prosecution. Please issue notice to the second respondent. Notice before admission, issue notice to second respondent only. List this case on 28 level. Yes.
Item number 2, Mr. Muhammad Abibuddin.
Easy BJP. Yes.
11th October, page 9.
Yes. Read the interim order.
Solution, there shall be given direction to the
Yes.
Next page 12.
Page.
Page 12.
Yes. How can I know that these photographs are relating to after orders being served on them? Yes. 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 Where is the acknowledgement you have submitted? Order copy acknowledgement. How can you presume that even on the very same day it will be reached the respondents? It is dispatched on 11th October. It may reach 12th or 13th or 14th. How can you say that it has been already received by them on 11th October? Where is the copy acknowledgement? What is that pen drive? On what date you have taken video? Is notice before admission. List this case on 28 level.
Item number 3, Mr. Venkatraj Shankar.
Yes, who is appearing for? Yes. What is that counter says? You have already registered crime.
Yes,
Before you have registered, the direction was only directing you not to interfere with the civil rights. And this court never directed you to not to register any cases or investigation into any of the crime. Therefore, there is a question of why you are interfering with the civil rights. No representation for the petitioner. No representation for the petitioner. List this case on 28 level.
Item number 4, Mr. Commissioner Reddy.
Yes.
She's the owner of the
Owner of the?
Yes.
Yes.
Model 17.
Yes.
Any particular function of the sergeant in the petitioner. Vehicle was given to him.
What is the vehicle? Model?
2017.
50,000. Dispose. 50,000. Whatever may be, release the vehicle subject to paying 50,000 rupees.
Item number 5, Mr. Surinath.
Two 8 cages. Block jaggery. Block jaggery. So why you are seizing the vehicles now? Read the relevant Panchanama copy. Yes. Yes.
వాహనాన్ని తనిఖీ చేయగా గూడ్స్ వాహనాన్ని 14 కాటన్లు బెల్లం సుమారు 20
అదండి బెల్లం అని అంటే ఏ బెల్లం?
దాన్ని అక్రమమైనదిగా గుర్తించి తాండాల్లో మాంసాహారాన్ని చేసే వ్యక్తులకు లాభంతో అమ్ముతారని తెలిపాడు. ప్రకారం మరియు ప్రకారం నేరం
Seat also there, page number 20.
It too much. That's too much. Page number 20. Same terms. Dispose them. What is that amount this code directed you to deposit? Very same amount, 1 lakh rupees. No. 50,000. 75 years.
ఓన్లీ వెహికల్
Only vehicle I am directing. Yes. Yes, what do you say? Yes, the understand on period 6 time to get instructions. Is this case on 40
Item number 7, Mr. Samir Kumar.
I tried the voice number 85 of 96 and got the order report from that partner. That also mentioned different government number. That's one number 7, finding cases.
Yes.
Repeated the cases. And then now it's really like peaceful position. PS and give it a complaint. Not registered any case.
If somebody is interfering, you go before civil court, obtain an injunction.
Already actually
If the violation of injunction, you file a contempt against under order 39 rule 2A or ask for the police protection. So what? You file a contempt. If he is digging a borewell, what? Digging a borewell subject to obtaining of the permissions under the Volta Act. You go and submit a representation to the concerned Tahsildar saying that without obtaining any permission under the provisions of Volta Act and he contrary to the injunction, he is digging a borewell, they will seize the borewell also. There are two favors in your favor. One is an injunction is in your favor and the other is without obtaining any permission under the provisions of Volta Act is proceeding. Is it your case that the respondent has not obtained any permission under the provisions of Volta Act?
Respondent also filed the case against me and the result also defeated in the court.
You are not following the suggestion being given by the court. See, is it your case saying that the respondent without obtaining any permission from the competent authority under the provisions of Volta Act is proceeding to digging out the borewell? Is it your case?
Yes.
Where you have stated about saying that he has not obtained any permission under the provisions of Volta Act in your affidavit? Then how can you file such a writ petition? Already closed the account, saying that there is a civil dispute. You file appropriate writ petition. Either you file an application under Article 39 Rule 2A saying that there is a contempt, or you file a fresh writ petition saying that there is no, or make a complaint to the concerned Tahsildar saying that without obtaining permission under the provisions of Volta Act is digging a borewell, there was an injunction operation. Therefore, your authority is not supposed to grant a permission. Even if any permission being granted, it requires to be cancelled. There are so many cases. How can you straight away file a writ petition? Even you have not verified the Volta provisions of Volta Act. So senior citizen law is something else. Then senior citizen means what? See, you have to, you are an advocate. You are not following, you are an advocate. You have to advise him in a proper way, saying that first give a complaint to the Tahsildar and who is the competent authority under provisions of Volta Act. Then now they are saying they have already closed your complaint, saying that it is a civil litigation. You file a protest petition if you so want. Yes, or you want to liberty, I will allow you to withdraw the writ petition, file a fresh writ petition after giving a complaint. Is the petitioner seeks permission to withdraw the writ petition. Yes.
Item number 8, Mr. U.
Yes.
D4 and 5, one is civil dispute. What my police station on the complaint was done. There is single civil dispute before the courts have filed a
Complaint lodged by your son.
Yes, there was a dispute earlier because my wife committed suicide while he was a minor. So he was taken away by their parents, grandparents, maternal side. And now he has grown up. Now my brother-in-law has completed the logic completely. There are several pending I have filed a material papers also.
Have you married after expiry of your wife?
Yes, madam. Now presently I am married.
Why you want to denying a share to the sixth respondent?
This is the very second day after the payments of my earlier wife committed suicide. For which a complaint was registered by Banjara police on the very same day under 134. Thereafter, after lapse of 6 months, again a private complaint under 306 was lodged. That was admitted recently by the lordship, my lord, the Ranigar. So now, because all the criminal case filed against me was gone, now my son was prompted to lodge a complaint. You know that between me and my son, my lord, I'm not going to that. I need to pay the paragraph 8 and 7, my lord. ACP has nothing to do with me calls my police station. I have translated in Telugu otherwise. So it's the worst for the last.
You follow the procedure as contemplated if the presence of the petitioner is required for the purpose of investigation of any of the complaint and following the follow 41 and Ernest Kumar guidelines.
No, I have obtained the stay of all further proceedings. I have filed a
You have obtained stay of all for the very same case.
Yes, ma'am.
Very same affair.
I must dispose of my representative to commissioner against the ACP, CS, SI, who made me stand for 40 minutes and wanted to remove my pants and stand in the road. My specification on 7 and 8 paragraph.
Where is that?
Yes, ma'am. I mentioned in my exhibit, madam. Page number 10, madam.
Yes.
Reiterating, madam.
Yes. Yes.
So 6 and 7. 6 and 7 on the page 10. We have read out only 6 paragraphs. The submitted type of report to accept the respondent of the ACT chamber, the respondent of the Pankari. So that I shouted at me and asked me to stand at the door and asked me to who asked me to come inside and sit in the cabinet. So she said that I am a criminal and repeatedly warned me that he will remove my pants and make me stand on the road and also snatch away my keys. Now he has saying that my keys of my flat, which I am the owner, I am paying EMIs. And now they changed all the door locks, my lord. I'm only concerned about this.
How can you establish that the police have taken this keys from the?
That is the back page. Everywhere there are cameras, but we cannot claim it. Let's say today I'm going to make a lordship. I'm conscious what I am betting, what my client has instructed me. On the last date on 30th, specifically when the lordship he has specifically asked for to get an instruction on this case.
Yes, what is?
Clear from A section.
What instructions? I will dispose the writ petition directing the commissioner to examine the complaint and take appropriate action in accordance with.
That way they made the same supplement before the admission.
This writ petition is filed questioning the inaction of the respondent, but will not take wife as a Binami and overcoming the Binami Transactions Prohibition Act, then you establishes before the such a court, obtaining a declaration degree, then you will become as the owner. Otherwise, he is a natural son of your wife, and automatically. Therefore, how can you say that you are even if you are in possession of the flat, it is an illegal possession. He is your son is the owner.
There are two flats, 302 and 402.
I am not going all these things.
The petitioner claims to be an agent of the plot number
That
7.
agent-
Number 9 is Amy Hanma.
Yes. Yes, Anandram. What is your
case and
Mantrao? What is your case? Tell me first.
They came to the and threatened with that.
Who came to your property? Then what is the course you have to initiate if somebody comes to your property? But after an injunction,
That is there. Injunction order is there.
so why you have not?
Despite the High Court order,
Why you have not made them as a party respondent to the writ petition?
my grievance is only against police.
Your grievance is against only the police
Police
for not registration of the crime against you. But therefore, who are affected by registration of the crime? Who are the persons affected by the registration?
They register again, then the cause of action arises for the respondent.
No, no.
They don't register a case, but again the respondent.
Yes, what do you say? You have already closed a complaint. You file a protest petition. Survey copy of.
They have registered a claim against this person on same day. Case and counter.
Sanmantrao, you are an well experienced company. You are having so many remedies. File case after case against the police. Yes. Serve the copy.
Yes.
Yes. The case of the petitioner is that is, the petitioner claims to What is the complaint you have submitted? Please read the complaint. Read the complaint. See, if there is some violation of the terms and conditions of the contract, you are entitled to invoke the arbitration clause, or you are entitled to approach the complaint civil court. How a criminal complaint is maintainable on the violation of terms and conditions of a contract?
What happened in March, sir?
I don't know what happened. I know only when the terms and conditions are violated. See, when the terms and conditions are violated, you are only having a cause of action to invoke the provisions of arbitration, or for filing of a suit for recovery of the amount, or violation of breach of contract terms, something. But how you are entitled to? Who manipulated the record?
Which contact is done with the admission response not the manipulated of my which is supplied the material and everything. The delaying that
Invoices are with you. Once you have supplied the material, you have to raise the invoices. How can the person who purchased the property would raise the invoices?
but they given work order.
Then a work order and invoices are in your custody. Where is the custody? How can you say that they are the custody of the person who is executing some work?
The work order given by the respondent. That delaying.
Yes, what do you say? The work order has been given by whom? Yes.
Theoretically, they done the work, they write the invoices, this invoice, contract invoice is there, but this invoice is delaying. That's the page number 23.
It is absolutely you are converting civil litigation into a criminal litigation, and the sixth respondent is none other, ninth respondent is none other than the Larsen and Turbo Limited. They will strictly follow the terms and conditions of the contract and arbitration clause being. Show me the contract entered by you. If there is,
Orally, extended.
I don't know about oral contracts. Only
Page number 23 onwards.
page number.
Page number 23, WhatsApp conversation with the
WhatsApp conversation?
with the respondents.
I don't believe WhatsApp conversations. I don't believe WhatsApp conversations.
Invoices was write the invoices.
Show me the written agreements. Show me the written correspondence. Show me the correspondence being addressed by the Larsen and Turbo.
Yes, this man, page number 26.
These are all created.
These are main.
How can I know that whether it is WhatsApp information or the message being received?
Mail everything. The invoices are in. Mail to the respondents.
What is there in your WhatsApp message? See page 22. Sir, paints work order के लिए please कुछ कीजिए. Then come to you. I am only referring to your message, WhatsApp messages only. Sir, paint work order के लिए please कुछ कीजिए. Sir, me project office memo free horn P बुलाए गया. You see, they have sent an information to you. Come to project office at 2:30 along with billing details for painting. That is the information they have given. Come to project office at 2:30 along with billing details for painting. That is 2:33 p.m. on 28th September. They have promptly answered to you, requesting you to come with all the where is the question of your complaint? See, there is no prima facie material on your complaint. Go before criminal court and file appropriate case if you are having a material in your hand under section under 156(3) for seeking reference. Otherwise, I will dismiss the case. What is that inquiry? No, I don't allow them to conduct any inquiry. It is not their duty to intervene into the civil disputes of this nature and conducting an inquiry. There is have some other business for the police.
Any submission that, how are the parties that?
And you are not following the instructions, I will dismiss your case. See, I will allow you. What is that leave it? I am dismissing. The petitioner, this petition has been filed.
I'm
Saying this court.
I brought up.
Respondent number 7 and 8, you lost calling the petitioner to the police station and forcing to pay the payments to the respondent.
Forcing?
Petitioner, come to the police station and forcing to pay the payments to the respondent number 9. The 7 and 8 are the sub-inspector of police and KB is the class person.
There is already interim direction is there in your favor. What is that you want? On the said direction, I am disposing the writ petition. Ready? Case of the petitioner is that he is engaged. Cause the FIR is, it has to go before other roster bench. I don't have any.
It is involved with the lab report. They went to the private lab.
You are not following. See, I don't have any roster to hear the cases relating to quash of the proceedings.
Investigation is not in accordance with the law.
What is that prayer you sought in this petition? Conducting for fair investigation. Say like that. Mononymous declaring the action of respondent 5 for not considering the letter dated so and so and not conducting fair investigation in relation to crime number so and so. Registered the Chingalguda PS against article against to the Chingalguda PS against to the article 1421 of Constitutional Principles of Natural Justice. Answer direct response to call for the records pertaining FIR number so and so registered and consequently cause the same. Therefore, it has to be listed before some other court. See, the prayer consequently is asking to quash the complaint FIR number 944 of the relief sought in this petition is seeking to quash the complaint in FIR number 944 of 2022 dated 2/22. Registry is directed to list this petition before the bench having rostered to hear the quash proceedings. Yes.
Item number 13, Mr. Tayyad, Nagmul Hasan Boxing.
Yes. You want to pass over? Yes, pass over.
Item number 14, Mr. Venkatraman.
When it was listed on 30/10/2023, why it was urgent to today? Yes, what do you say? Have you received any instructions?
Yes.
Yes, what? What is that relief you are asking? 60?
64.
Yes.
The fourth respondent is an defect of complaint in the same crime is committed nearly 10 crimes. The A1 is the defect of complaint against the after. Whether in the said counter blast only, they are registering the FIR 116 of 2023. Whether the petitioner A1 is approached Assistant Commissioner of Police and lodge a complaint to conduct a detailed inquiry. But this answer is passed order. But till today, the police not registering the rowdy sheet against the defect of complaint. Since 10 crimes, you are lodged directed to the police why they are not registered the rowdy sheet. Whether the defect of complaint is
Where is the direction? This court directing the police to open a rowdy sheet against the
previous.
Where is that order? Show.
The same case is post along with this petition.
Yes, list this petition. List this petition along with that petition number so and so. When you want to file counter? Yes, the petitioner is permitted to take out personal notice to 456 and file proof of service. List the petition along with the WP number so and so. Yes. For filing counter affidavit. File a counter affidavit. When a person coming that against the respondent has involved in more than 10 cases, in what case you will open a rowdy sheet if you have not failed to open a rowdy sheet in for more than person suffering with 10 cases? We examine and file a counter affidavit along with that petition. Yes, call the next case.
Mr. Rapor Bhaskar.
Yes, Mr. Bhaskar. If they are not receiving, you file it, send it by register post. What you have already sent it by register post. When you have sent it by register post on 1910, why can't you wait for it? Give a time at least for 2 weeks for them? Read your complaint, what it says. We will see. Page number? Yes. తెలుగులో చదువు మంచిగా అందరికి వస్తుంది తెలుగు అందరికి అర్థమవుతుంది కూడా నీకేమన్నా ప్రాబ్లమా నాకైతే ఏం లేదు మరి మంచిగా చదువు ఏడ చదువుతున్నావు భాస్కర్ ఏ పేజీ 17 లో నేను అనగా మిరియాల రమాదేవి అన్నది అది ఎక్కడికి వెళ్ళి స్టార్ట్ చేసినావు చెప్పరా సబ్జెక్ట్ ఎందుకు లోపలికి పో
నాకు లోపలిగా మార్గం మమతాపురం గ్రామ శివార్లు కార్యం చేస్తాను ఇది పోతే నాకు స్వాధీనం చేస్తాను కాబట్టి నేను 15 పెంచుతాను ఈ మధ్యకాలంలో మూలమైన బాగా తిరిగినందున వీరస్వామి కలిసి ఈ డబ్బులు నీకు ఇస్తాం మా అమ్మ మాకు ఇవ్వమని డిమాండ్ చేసినాను దానికి నేను అంగీకరించలేదు దాంతో అందరూ కలిసి నల్ల
నేను ఊర్లో పంచాయతీ చెప్పాల్సిన కేసు ఇది పిటిషన్ వేయవలసింది కాదు This is this common problem in all the villages. It's the common problem in all the villages, Bhaskar. You are having a political experience in view of abnormal increase of the land rates in the vicinity in the entire Telangana. This type of cases being developed, the proper remedy for would be for you is to call the persons and compromise them and negotiate them. But how can a police register the cases? లాస్ట్ 4 లైన్లలో ఏమన్నా అంటే దానికి నేను అంగీకరించడంతో వీరందరూ కలిసి కర్రలు రాళ్ళు మరియు కత్తులు తీసుకొని నన్ను చంపుడకు నా వెంబడి పడినారు ఆ సమయంలో నా భర్త అడ్డు రాగా ఆయన మీద కూడా దాడి చేసినారు ఈ సమయంలో మా గ్రామస్తులు వచ్చి వారి నుండి మమ్మల్ని కాపాడినారు దీనివల్ల మాకు వారి నుండి ప్రాణభయం ఉంది దయచేసి మాపై దాడి చేసిన వారందరి రాగానే నువ్వు పారిపోయినావు ఇంకా నీ మీద దాడి లేదు ఇంకా మళ్ళీ నీ దాడి చేసిండ్రు కత్తులు తురుముచ్చిర్రు ఎక్కడ ఉంది ఎక్కడ రాష్ట్రం అది పెద్ద పిటిషన్ లేని లేదు ఇల్లు ఎక్కడ నువ్వు చెప్పినవేమో వాళ్ళకి అట్లా చెప్పమని రీడ్ ది 4 lines వాళ్ళు వచ్చే వరకునే మీ ఊరోళ్ళు వచ్చారు మీ ఊరోళ్ళని చూసి వాళ్ళు పారిపోయినరు కంప్లైంట్ ఈస్ రీడ్ ఇస్ లైక్ దట్ ఓన్లీ ఇట్ ఈస్ నాట్ ఏ కేస్ ఆఫ్ you go and file a private complaint improving your version to attract the ingredients of the offences. You improve your version before the you receive the complaint if it discloses any cognizable offense. See, it is there. This is in your presence only is saying to act upon the notice unnecessarily. Why you want to give a finding in a writ petition by this court which is having a far-reaching consequences? The findings given by the High Court is binding in the trial court. File appropriate. Why you want to take away right? You have filed. That's all. చెప్పు పార్టీకి జడ్జి గారు కొట్టేస్తా అన్నారు ఏం చేస్తామా మళ్ళీ ఉన్న కేసు ఖరాబ్ అయిందని మీరు డ్రా చేసుకున్నారు. Yes, at the request of 11th counsel for the petition. You want to record? Yes, yes. The case of the petitioner is that he has submitted a complaint. When the case of the petitioner is when the 5th respondent department.
Item number 16, the Puri Chandra Rao.
Yes, who is appearing for Mr. Purnachandra Rao? Yes, there was a direction, Mr. Gaurav Leader, to get instructions on by 6/11/2023 in motion list. Yes, what is the matter? What is that relief he is seeking? For non-registration of the crime. Have you acted upon the complaint? Uh, Telegram also they have sent 1329, page 27. See the telegram, come to page 27.
Dated 1/3/1999.
99. He filed a writ petition seeking for enforcement of the complaint being given in the year 1399. You read the relevant portion, therefore I will dismiss. Where he has stated about the complaint being submitted on 1399. 1399 means almost 25 years.
That date number 27. Dated 1/3/1999.
Come to the affidavit where they have stated. No action has been taken. 1/8/1984. 40,000, 40,000.
And the same subject matter, same issues are pending.
And the very same subject matter.
Yes.
What is that relief? It is also just and necessary that the Sound Court may please to direct the respondent 3, 4, 6 for eviction and handover of the possession of the petitioner were respondent 5 who are involved in a malified intentions with extraneous reasons, with trespass, with illegal encroachment, and planning to sell the house with wrongful claims, which was turned into gambling hub for illegal activities for playing cards, caroms, chess, etc. without any permission from APSRT administration and vigilance, which should be ఇంకొక్క రిలీఫ్ ఆయన ముఖ్యమంత్రిని చేయమని అడుగుడు తప్ప అన్ని అడిగిండి.
Both the petitions filed.
సార్ ఏం కావాలండి నాకు ఎవరైనా రాడు అది తెలుసు నా మైండ్. రండి. No representation for the petitioner. This writ petition has been filed seeking following relief. The case of the petitioner is
despite reporting a serious cognizable offence.
Read your complaint.
It is 14.
Yes.
So the complaint is dated 3/10/2023.
Yes.
The police station on the secretariat police station. Complaint against Mr. Napa is Swami. Number 2, Kaisula, Tanjungla Mandal, Telugu district. Number 3, Mandal Surveyor, Telugu Mandal.
You are entitled to file a complaint under 200 CRPC, Mr. Pratap. You are entitled to file a complaint under 200 CRPC.
There are two aspects which I here clearly reported along with the proof that the court responded to a representative that is the owner of the piece of land is actually not belongs to him, but the in collusion with the Mandal surveyor and the Mandal revenue officer, they have fabricated a revenue sketch map, survey sketch map, which you can see page 25. But here, the show that survey number 224 is extra together. But the fact remains is that as per the village map, in between this 216 and 222, there is another survey number called 250. But the surprising that fact, they have given this thing. And when we have taken this matter to the notice of the Mandal revenue officer, can you see page 26? This is the endorsement.
Page
26.
Yes.
In fact, this survey sketch is also on page 25, is attested by MRO. But later it turns around and says the surveyor has misguided and wrongly survey number 250 RGC and wrong reported by surveyor. It is a clear collusion with the respondent.
Even after such a endorsement being made by the Tahsildar, you are entitled to get a correction of the survey earlier conducted, or make an appeal to the inspector of survey, or make an appeal to the additional director for the survey or regional director survey. You can correct it always. This why you want to initiate criminal action?
The petitioner is no more interested in buying the land now. My only grievance is against the respondent of court and the officials, revenue officials who have cheated me. And this serious cognizable offence has not been taken cognizance by the respondent number 3.
You file a private complaint.
But my submission is that when I made this complaint on 3rd/10/2023, for 1 month it doesn't register the affair. It does not give me a response. Then the petitioner is carrying this matter to the superior authority, that is Deputy Commissioner under 154(3). While this complaint is in the purview of the Deputy Commissioner, the third respondent cannot pass any orders. Can you see their own circular?
What circular? Circular of whom?
Of the police department.
Saying what?
Saying there is a SOP in place when the police comes across this kind of disputes involving the land.
Yes.
There is a SOP in place. But this is dated 7/3/2022. Standard operating procedure guidelines to be followed by the police officers while dealing with complaint disputes and such other matters related to immovable properties. But it clearly says,
yes,
it is observed that a large number of persons are approaching police stations in connection with disputes and matters related to the land, agricultural land, non-agricultural land, meetings and sites. A lot of complaints are being received by the Commissioner's office against the police officers regarding their alleged over-involvement in land disputes. Media and also focusing negatively against the police officers on such. It is pertinent to mention that in the absence of standard title registration scheme in the country, the land grabbers are getting the advantage of giving the entire issue as a cause of civil nature and dimension of the cost of posing themselves as genuine aggrieved persons. For conduct of fair inquiry and provide such false allegations, a standard operating procedure is prepared which will guide investigation officers on proper lines. 21 situations or times in which police officers can receive complaints about land disputes, which are complaint after detailed seminars and taking feedback from stakeholders like police, civil, criminal, and revenue law experts are shown in the list attached clearly. Accordingly, the guidelines followed in all 21 situations have been already documented as SOP for the benefit of all investigation officers by the victims. But the main objectives of SOP, the following are the main objectives of the present SOP. Number 1, to provide a standardized framework set of instructions to police officers who are dealing with the land disputes. To discharge the police officers who are dealing with such cases.
Discourage.
Showing
it is not discharge, Pratap. It is discourage the police.
So, number 3, to reaffirm the legal commitment of the police department while dealing with such cases. And B, general SOP for all land disputes. Number one, while dealing with property disputes, there is every scope for making false allegations against the police such that they are not dealing with the problem in accordance with law, etc. While dealing with the property dispute, the concerned police officer shall summon both or all the parties to the dispute to be present before him or her. At the same time, all the required evidence with or without the presence of their advocates, advisors, if any. Number three, once both all the parties are with necessary evidence, the inquiry officer or the police officer concerned has to examine and decide which party is right. Therefore, if the concerned police officer finds existence of any criminal content, he or she shall register a case and inform the matter to the concerned TSHC. In case where any opposite party fails to appear, instead of receiving summons, the matter will be finalized based on the merits of the case for taking further action as per the provisions of CRPC. During the inquiry, it is revealed, if it is revealed that a wrong person is in the physical possession of disputed property, the person who is entitled for right to possession should be asked to approach appropriate forum for recovery of possession of the property in accordance with the public peace of the harmony. The concerned police officer shall submit a report to the proper concerned court seeking for appropriate directions to implement such order. The IOs are instructed to bring the notice of the concerned superiors whenever land dispute cases are reported without any delay. A separate file should be maintained at each and every police station, so it will be the nature and scope of all major land disputes for the benefit of successor officers. History sheet shall be opened against the habitual land-related offenders under subhead for professional land grabber. Under section 110 CRPC. Therefore, all judge CPs, zonal DCPs concerned are requested to direct their SHOs or the ACPs to strictly adhere to the above instructions and ensure that these instructions are complied with scrupulously. Any deviation or non-compliance in any manner will be viewed seriously and necessary disciplinary action will be initiated against the hearing officers. Therefore, out of the 21 situations, what can you see?
No, what is that you want, Pratap? Tell me.
Page 7.
Under which provision of law this police commissioner has issued these instructions? What is the legal sanctity to the police commissioner to issue? Is the instructions being any authorized by the any of the legislative sanction?
I'll go to that, but my observation is that
Can the police commissioner is having any power? If he is having a power, show me the provision of law and legislative sanction.
I'll also go to that. But my observation, as of now, the SOP stands there. Not when
No, those SOPs are not binding on this court. The case before this court is that you have some largely complaint, they are not acting upon. That's all. Whether any complaint has been disclosed prima facie cognizance and which confers the power on the police under section 154, or if a complaint being submitted to the superior officer on 154(3), whether he acted upon or not. These are only two things that would waive the court to take a decision with regard to directing the police officers. That's all. Not the internal instructions. These are the internal instructions to guide the subordinate officers, not to interfere with the civil disputes, so only to guiding factor. It is a guiding factor to them. But you are before me, before this court.
there is also a situation covered under this case.
What are your instructions? So, you file a protest petition, they have already closed their complaint.
For filing a petition also, there has to be nothing
Not necessary. Who said you are grieving? No. If they have not registered an FIR, you file a private complaint. Even not only it is necessary for a protest petition, you are entitled to file a private complaint under section 200 CRPC 156(3). It can be referable. Magistrate is having all the powers, and even without referring to the concerned police for investigation, magistrate can sumo to take a cognizance and number it in CC and proceed for issuance of summons.
all these kind of cases. What is that? There is a SOP of the police department. There is also a SOP based on the Lalita Kumar judgment. And there is also
Now your case, they have examined closed. There are only two options. One is filing a protest petition, another is filing a private complaint. I will leave it.
I can agree that if I am not disclosing a cognizable offense, I can go before the civil court or I can.
No, not civil court. You are entitled to file a private complaint when the police has closed the complaint.
Clear cognizance, there is a criminal.
Even the competent magistrate court is always having power to look into the grievances. Yes, right. case of the petitioner is the writ petition has been filed. Praying this court. Yes. Who is interfering with your question? Who is the fourth respondent? Why a fourth respondent is interfering with your question? Where you have stated about the civil disputes in your affidavit, show me. What happened to civil suit? Why you have not made him as a party respondent, a person who has lost the civil suit against you?
He's not in. Oh, and he's not in, he remained expert.
Hmm.
Right, of some third parties, the police in state temple. If it is the police, not in the police.
Show me the decree copy.
27.
Page.
Where the business of T4, it's not T4. Statutes of degree. Of it is violent.
So what do you say? Hmm? To investigate into this crime. Yes, right. This repetition, the repetition came to be filed to declare the action of the is required for the purpose of investigation in any crime, the respondent police are at liberty to take appropriate action in accordance with police law. However, this order does not apply. However, this order does not prevent the lawful owners, does not prevent any Release of the vehicle.
These are the vehicles. By on 5/7. But found in positive in the target and based on the petitioner approach the respondent for the releasing document. Refuse to release the document.
Go before the competent criminal court. If a vehicle has been shown as an offensive vehicle, you are entitled to file an application under section 451. Is what do you say? What is the normal procedure? Earlier orders passed by this court?
Yes.
You produce the documents with the. And yes. You are having copy of the order dated 1647 of 2021.
In the batch of cases, we enter this honorable court by Justice Rashman.
Yes.
Government, police have no other to detain the vehicle. If it's produced by the other person, the relevant document is found to be in the vehicle.
There is that order. The WP order, 1647 of 2021.
21.
Dated 29/10/2021. చిన్న ఉంటే తీయండి లాస్ట్ డేట్ లో అవసరం లేదు లాస్ట్ ఆపరేషన్ పోర్షన్ D. Yes. The case of the petitioner is that is managing director, managing partner. Petitioner,
Petitioner is complained in traveling abroad. That he has reached authorities on at least 2 courts. There is a natural dispute between petitioner and his wife. And after the dispute, going to volunteer case has been instituted.
why you have not made your wife as a party respondent to the writ petition who has lodged a complaint?
The court circular, this court circular is not served on the petitioner. And my lordship, HIGHCOURT versus Union of India. Supreme Court has categorically.
See, I am putting a question to you. Why you have not made the complainant as a party respondent to the writ petition? At our instance, only 498 has been registered. At our instance, only 498 read with 3 and 4 Dowry Prohibition Act has been registered and acting on the complaint of the de facto complainant. The respondent police have issued a lookout circular. Your grievance is the issuance of lookout circular is illegal. Police acted upon the complaint of the de facto complainant. Why you have not made her as a party respondent? Yes, petitioner seeks time to implement the de facto party respondent to the writ petition. List this case. When do you want? Yes, list this case on 28/11.
Item number 21. MD Bharti.
May I please your lordship?
Yes.
Petition is filed, my lordship, aggrieved by the action of respondent police in not conducting inquiry from respondent number 4 and 5, my lordship, and taking cognizance and registering FIR, my lordship. Page number 18 is the fake Aadhaar card, my lordship, used for the registration, my lordship, by respondent number 6, 7, 8, and 9 in collusion with respondent number 5, my lordship. So hence, my lordship.
Yes, the land gone pleader seeks time to get instructions. List this case on 28/11. Yes.
Humble submission, my lordship. I have made Director UDI Regional respondent number 4, my lordship. Instructions from respondent number 4 is essential, my lordship. As if now.
We will see. Let the police may get instructions. Yes.
Item number 22, Mr.
Nagesh. Yes, Mr. Nagesh. Yes.
Aid of the police protection, because already there 2 affairs are pending with the community people who are disturbing me, made a commotion, and last occasion 2023 May, June, they ransacked my house and beaten us. I filed also with photos.
Yes, what do you say?
Now they are determined to vacate the house and not there from there, and at least to vacate the time also. Every time my vehicles come to there and they are making transfer.
Who are making?
They are the accused in the another FIR.
Who are the accused?
Accused in FIR was page 21, 28.
Who has filed this criminal petition number 7796 of 2023? Who filed that some criminal petition?
We have filed.
Why you have filed a criminal petition?
They have filed the counterblast to my case.
Therefore, admittedly, there are disputes between you and others. Why you have not made them as a party respondent to this complaint?
Already they are in the FIR. They are accused in 2.
They are accused in FIR. They are not the parties to the writ petition. Why you have not made them as a parties to the writ petition?
Only we are seeking a direction to the police. Because there are 2 FIRs.
What is the direction you are seeking against police?
Aids. Police.
Against whom? Aid you are seeking against whom?
Because
Against intervention of whom?
Other than these accused, newcomers are coming. I do not know. I am only the tenant for last 2 years.
You vacate and go. You vacate and premises go there. There is. Then why?
To me already my.
Once you vacate the premises and go from that place, where is the disturbance to your life? Tell me. Go and reside wherever you.
My vehicle come to there.
Why your vehicle is coming, since you are residing in particular disputed area, vehicle is.
To goods to vacate myself.
Hmm.
They are making commotion there. What is the reason we do not know? We did a survey.
What is the reason? I also don't know, because you have not made the contesting parties.
Remember what was the use?
Not only you, I also don't know why you have not made them as a party respondent to the writ petition.
They already they are convicted in this. Both affairs are there.
Yes, what are your instructions?
Only simple direction also in which at least the police name 100 police and also the constable name, because they are this.
Provide they want to vacate peacefully, they want to live a life with vacating the premises.
No action at all. What is this? This is civilized conduct.
Get instructions by next week. Yes. If it is possible, suggest the police to accompany at least two constables, they will vacate and go, they want to peacefully leave.
Any day when it is being important.
అంత మంచి చెప్తున్నాడు,
Doctors.
మంచి మంచి తెలుగులో చెప్తున్నాడు, ఇంగ్లీష్ లో చెప్తున్నాడు, నీకు అర్థమైతే లేదా? అదే అంటున్నా. Get instructions. At the request of the learned assistant completer, list this case for instructions on 2011. దీపావళి హ్యాపీలీ చేసుకుని బయటకు పోయి. When do you want that 1411 I have posted? Get instruction that case, earlier case. 14. Yes.
May it please your lordship, my lordship, the present writ petition is challenging the action of the respondent number 3, my lordship, without having any FIR, my lordship. They are calling the petitioner to police station, my lordship, and making them to sit. Let them follow due process of law, my lordship. That's the only request.
Yes, ready. Yes. Follow the procedure. The case of the petitioners is that the third respondent frequently summoning the petitioners to the police station, even without registration of any kind. What is this writ petition you have filed, WP number 39?
My lordship, previously the petition number 1 filed a writ petition, my lordship, in that the court already directed the police to follow 41A, my lordship. But in spite of that, my lordship, they are not following, my lordship.
In spite of directions issued by this court, when the respondents are not following the procedure as contemplated in Anish Kumar or issuance of notice as required under section 41 CRPC, what is that action you have to initiate against the police under the judgment of Anish Kumar? As for the guidelines issued by the Anish Kumar under class 6 and 7, if the guidelines issued by the Anish Kumar has not been followed, it amounts to contempt, a serious contempt on the part of the respondent police. Instead of filing a contempt, why you filed a second writ petition on the similar set of allegations?
My lordship, in that writ, my lordship, only petition number 1 was there, my lordship. Now they have been calling all the petitioners, my lordship.
Now the petitioner 1 is also party to this writ petition.
Yes, my lordship. If they have any complaint, let them file an FIR, let them arrest also, my lordship. We are okay with that.
It is not your case. It is now the case of the court. The moment you have brought to the notice of the court that the respondents are not following the guidelines issued by the Supreme Court, Supreme Court specifically directed the High Court in the very same judgment to initiate contempt action against those people.
Yes, my lordship.
Now, the moment once you filed and brought to the notice of the court about the action of the police, the court will seize of the matter, and it is my duty to look into the court's orders being implemented or not. It is not for your botherance. Having filed a writ petition on behalf of the first petitioner, the first petitioner is the petitioner in this case, Muhammad.
Yes, ma'am.
Then why you have made him as a party once again? For the very same
time. Other than petitioner number 1, lordship can grant order for other petitioners, my lordship. At least.
That is
let them have protection, my lordship, their family members.
The case of the petitioner is that respondent number 3 is frequently summoning the petitioners to the police station even without registration of any crime.
Without registration of any crime. It is specific case of the petitioners on the petitioners that on 18/10/2023, 22/10/2023, 27/10/2023, 31/10/2023. The fourth respondent, the third respondent has sent constables to the petitioner's house. The case of the petitioner, first petitioner is that questioning it is further case of the petitioner. The case of the first petitioner is questioning questioning the action of the respondent, third respondent. The first petitioner already filed a petition by WP number 39232 of 2022 on the file of this court. And this court disposed of the said petition directing the respondent's hearing to follow the procedure contemplated under section 41A CRPC and also the guidelines issued by the Arnesh Kumar versus State of Bihar system. The grievance in the present in this petition is that the except first petitioner, remaining all other petitioners are frequently summoned to the police station and confining hours together without disclosing any reason or without informing that their presence is required in any of the criminal cases for investigation purpose. It is settled proposition of law as per it is settled law that as per the it is settled law as per the guidelines issued by the Honorable Supreme Court in Arnesh Kumar versus State of Bihar. If the presence of the petitioner is required, presence of the accused are required for investigation in any case, the police would follow. The police ought to have followed. The police has to follow. The police has to follow the procedure contemplated under section 41A CRPC. And after issuance of notice only, they are entitled to proceed further with the investigation. Admittedly, it is the case of the petitioner that even after directions issued by the this court in WP number 39232 of 2022.
Admittedly, it is the case of the petitioner that even after directions issued by this court in WP.
So and so WP number 39232 of 2022 dated 21/10/2022. The family members of the petitioners, first petitioner, was called to the police station. On the allegation for the purpose of inquiry on the complaint lodged by the first petitioner wife and interfering with the matrimonial disputes. In view of the said submissions, in the learned government appearing for the respondent submitted that the fourth respondent has filed a complaint. RGD report filed a complaint dated 5/9/2022 and GD entry was made. And for the purpose of inquiry, the petitioner's family members were summoned to the police station. But the respondent police have not harassed the petitioners in any manner. The respondent police are not harassed the petitioners except making an inquiry. In view of the said submissions, this court deems it appropriate to dispose the writ petition directing the respondent, third respondent, to follow the procedure contemplated under section 40A CRPC and also guidelines issued by the Honorable Supreme Court in Arnesh Kumar versus State of Bihar. If the presence of the petitioners is required for the purpose of investigation into any case, investigation in any crime. Above observation, the petition is disposed of.
Highly obliged, my lord.
Item number 24.
Case. Case, what do you say? What is Ratna Women Hair Enterprises means?
He's an expert of human hair.
Mm.
And during that course, he contacted respondent police a customs agent
Mm.
of the client.
Mm.
And that customs agent, while making the shipment,
Mm.
made fortune documents to the court, seals everything. And he enhanced the price of $1,200 to $3,600 thereby.
Yes, right. The petitioner is permitted to take out personal notice to the respondents 4 and 5 and file proof of service. List this case.
Item number 25, Ms. Dinesh.
Yes.
To court circular. Yes.
Spending, even is, that I am getting the police. How it was here, should explain. The offense is against me is that we are created for Muslim marriage.
3 and 4 of
Muslim marriage. That is about talaq. It's about 14 is the
what it says, section 4 of a Muslim Marriage Act.
triple talaq is illegal.
Or under section Muslim Women Protection of Rights on Marriage to Act 2019.
Yes.
According to you, it is violation of the so and so.
Yes.
Therefore, you are liable for the prosecution. What is wrong in it?
Right. But that also that I said only one notice. I have not pronounced the word and I have pronounced it 3 notices.
According to you, there is no talaq at all.
Yes.
Following the triple talaq system.
Yes.
Therefore, right or wrong, now the crime has been registered under section 397 of.
System Millet, I am appearing before the police Millet. There are 41 is served on me. But I am appearing with the police.
Yes, right. The petitioner is the husband of sixth respondent. 1 minute. The case of the petitioner is permission to go to abroad before the competent court. Such an application is filed by you, the court below is directed to consider the same.
Yes, Rahul Bhaskar.
Consider. Yes. Yes, madam. Yes, what do you say? You already registered the claim, right? This repetition is, this repetition came to be filed. Questioning the action of the respondent number 4.
Then producer Mr. Katkiran.
Not in visiting affair based on petitioners dated 9/10.
Read your complaint. Read your complaint, madam. Page 16. What is that evidence to say that you have paid 1 crore 60 lakhs? Is there any agreement you have entered while paying that amount? If agreement has not been complied with terms and conditions of agreements being not complied with, what is the course of action left for you? You have to institute a suit for specific performance. Have you instituted any suit for specific performance? And you are aware that even oral agreement also enforceable in law, subject to your establishing before the competent civil court that you have entered in agreement of state. Oral agreement, I am saying about the written agreement. That is the specific performance. See, what are the except saying one sentence, వాళ్ళు నన్ను చంపుతామని భయభ్రాంతులకు గురి చేస్తున్నారు. Nothing else is there in your complaint. I will dismiss this writ petition. Why pass over? ఇంతకంటే మంచి ఇంకెవరు ఆర్గ్యూ చేస్తారమ్మా? You have argued well. Why you want to pass over? I will dismiss and this petition is, or you want to withdraw? The petitioner seeks permission to withdraw the writ petition with a liberty to avail the remedies as available in law. Permission is granted, writ petition is dismissed as withdrawn. Yes.
Bill number 28.
Yes, Mujib.
This is the complaint which has ever been made. Police has registered a crime and seeking complaint.
Yes. No, whatever may be, now crime has been registered. What is the
Police registered for page 14.
Yes.
SI K. Shivakumar.
Yes.
14.
Yes.
This dated 19th.
Yes.
SI K. Shivakumar, working at Habibnagar police station, received an oral complaint. Can you see this matter?
Yes.
From Sri Abdul Quddus Venture, that he has given his property, residential house on rent to Muhammad Abdul Rahim. This Muhammad Abdul Rahim is also added as a petition number 2 before Lordship. 20th May 2021 for a period of 11 months as per the rental agreement. There is no rental agreement, there is no tenancy matter. The tenant Abdul Rahim is closely associated with the notorious published leader Jagdish Yusuf of Habibnagar police station. This is the petition number 1 matter. After the election notification matter, now I am very sorry to say, the present police commission, not only this FIR, yesterday and day before yesterday also matter. Before this 1000 police also 3 more FIRs like this have been registered against against the workers of one political party. The said person Muhammad Abdul Rahim is not vacating the portion and postponing the dates by simple reason. Additionally, Rowdy Sheeter Jagdish Yusuf has intervened in the matter and threatened the owner by name Abdul Quddus by demanding ₹5 lakhs to settle the issue. Because of his notorious activities and this criminal background, Jagdish Yusuf the complaint on Abdul Quddus by his family members are unwilling to file a written complaint against him. That is the obligation. On the basis of the oral complaint,
No, what is that you want now?
Because under the guise of
There is a complaint against you. The same was acted upon and registered. Legality or illegality, I cannot decide in the writ petition. You are entitled to file a quash proceedings if you want to challenge the complaint itself. It is abuse of process of law. But what is the relief you are expecting in the writ?
seeking that. The police is using this tool, this affair as a tool to harass him in order to prevent him from participating in the election campaign. Let them investigate Melat before taking any coercive steps against him. That is my proposal.
I can't grant any such thing. During the election season, I am not supposed to.
Oh, Melat, first of all, kindly see Melat. There are no cases pending against him.
Whatever may be,
Let
then
them
now
provide any cases
FIR is pending against you. This 291 of 2023. Dated 19/10/2023 has been registered.
2023.
And see, the rowdy sheets can be opened when there is a threat to the public at large. See, according to the notorious activity and his criminal background, the complainant Abdul Sohn and his family members are unwilling to file a written complaint.
That's not so.
That is the allegation. It may be true, but there is an allegation saying that no. See, rowdy sheets can be open even if some of the witnesses are not coming forward to register a case against particular person because he's a rowdy. Nobody will put into their life into a risk. Therefore, the police, the sub-inspector has addressed a letter to the circle inspector. These are the reasons for nobody else is coming forward to register a crime against him. So what is the direction you want? Let them get instructions. Yes. Yes, what are your instructions?
Should have what one of these two. A1. A2.
Yes.
More is there for us, my lord.
My lordship.
I have stated.
ಅದು open in the year. 19 times it is more.
Yes, list this repetition for counter. List this repetition for filing counter affidavit on 4th December. Yes.
Before that, may make it submission.
See, you wait on the day if it is necessary, I will quash. If you insist now to pass an order, I will pass an order.
I'm not insisting for a final order.
Yeah, I will pass a final order now. You question this final. No, you do one thing, Mujib. You question this final order before the appropriate. No, no, no. They said that they have followed the 41 and you are abstaining. I said you don't want that. Because of elections up to 30th November, there is no question of granting any interim relief. I am clearing you on in there. That's what I am saying for filing counter affidavit. List this case on 2nd December. Meanwhile, petitioner, you no. Otherwise, otherwise I will do one favor. I will pass an order rejecting your petition. You file an appeal. Then single judge. I may be wrong. My opinion may be wrong, but you are entitled to contest the matters before appeal.
Your lordship is not wrong. I'm not
See, I said the cases where there is a police circulars also has been issued. In what cases the police can interfere during the election process? The mere suspicion is enough for bind over under part 8 of the CRPC. These are the so many things. Therefore, court should restrain exercising its powers under Article 226.
fully in the agreement with your lordship's opinion.
If you say that he is not having any history of the rowdy sheet, I would have been considered straight away granting an order. He is involved in 18 cases.
No, those cases are closed.
Whatever may be the reason. No, I am not saying that closed or he really is a culprit of the said allegations. But he was an accused in the 18 criminal cases pending against him. In even a person who is facing 18 criminal cases or faced 18 criminal cases are ended in acquittal, or some of the cases are pending, or some of the cases are before Manning courts. Still, during the election season, if I exercise a discretion admittedly, it amounts to unfair on the part of the 226 jurisdiction.
Only one grievance. Only in agreement with the lordship only. There is no complaint. They said on the basis of one complaint.
Not necessary. While traveling on the road, they are searching the vehicles and they are searching the vehicles during the election. They are seizing some articles from the vehicle, saying that the election commission has issued certain regulations. It is contrary, and it is burden on you to go before a competent criminal court saying that it is money. I am having legally secure this money. Therefore, if they started coming to this court, release of the money, release of the article, what is the purpose of the search and seizure of the vehicles? Tell me. Therefore, court should also, in a reasonable cases, come. If it is only one case where a case is registered against you, I would have been granted an order. You are already a known person in that locality. You should understand known person means. Yes, call the next case. Yes, Kumar.
412 listed. 212 listed. 412.
412. Yes, Kumar.
Suit for declaration of indication is pending. With the course of cross-examination, a suggestion was given to the plaintiff PW1 that is not in possession of the property. Therefore, an application was filed seeking appointment of advocate commissioner. And that was allowed by the trial court. But you find my lord that judicial order at page 73.
Yes.
Including the matter to note on the possession.
Yes.
That was challenged before the Honorable Court by the defendants. When a notice was ordered.
In a revision. In the revision.
I made my appearance and that is pending. In the meantime, when I insisted the commissioner to visit the premises, now they influence the police. Now the police part interfered with the civil dispute. returning it hoisting of false cases to withdraw the case and also my complaint. Not a use vulgar language.
Tell me other language available to the police to use.
Police language.
కాదు కుమార్ నేను పిలిచి ఒక రౌడీ షీటర్ని పిలిచి పోలీసులు రండి సార్ దయచేయండి కూర్చోండి కాఫీ తాగండి అని కూర్చేస్తే రేపు నుంచి వాడు వింటాడా మనకి పోలీసు టెల్ మీ యు మే బి ఇన్నోసెంట్ ఐ డోంట్ నో బట్ థింక్ ఇట్ ఈస్ అన్లెస్ ఇన్వెస్టిగేషన్ హెస్ బీన్ కంక్లూడెడ్ నోబడీ కెన్ సే రేపు నుంచి అదే చెప్దాం పోలీసులను పిలిచి రండి కూర్చోండి కాఫీ తాగండి బ్రేక్ఫాస్ట్ ఇడ్లీ ఏడికెళ్ళి తెప్పిమంటారు. That is only the friendly front is using of language only the friendly flow is. If using a third degree method, it amounts to you are right in saying something. Well, because language they have been trained and said language.
My only grievance is the suits are pending. Not an order, you lordship can see the order.
Yes.
Second commission was appointed about to visit. No, my lord, the truth will come out.
The judgment related to know what is the judgment page 87?
Lord, interfering in the civil dispute are depicted by Sapa.
That is settled law. That is settled law. There is no need of reference of any judgment. That is settled law. The police are not having any power to interfere into civil disputes. Is settled law. But nowadays civil disputes are giving cause for registration of the criminal cases. Therefore, the police has to apply their mind whether it is a civil dispute or whether there is any criminal intention being involved or motive is there or attracting the ingredients of the criminal cases. Therefore, they are entitled.
If they register the FIR, my lord, the lordship are correct. Without registering, kindly have a look at the order of the trial. But this is the cause of
Yes, what do you say? Without registration, why you are interfering into civil disputes?
No, there is a serious threat of disposition, my lord. Now, 2006 litigation is going on.
How can I say that you are in possession of the property?
But injunction was granted against the respondent not to alienate.
That is the different issue. You are not to alienate is a specific performance suit.
But that is all. That is the.
In a suit of specific performance. In a suit of.
I am in possession of the property by virtue of adverse possession. That is my grievance. But since 2006, suit is pending.
But the true owner is always entitled to inspect his own property. There is case law saying that the true owners always entitled to inspect their properties.
No, alienation was taken place. Now the alienation are.
If alienation is.
On paper, alienation was taken place.
In this court is having any power to decide that the particular person.
No, only grievance is kind of 73.
Yes.
Only to first
Come to your suit. What is that your relief you are asking? Declaration and perpetual injunction.
No.
Read the contents of the document. Plaint.
Page 44, amended plaint.
Why amended plaint copy?
No, this plaintiff part 1, 3, 4.
Page
42.
Yes.
Now, original plaint you have to find at page 34. Originally, 4 plaintiffs filed suit against 2 defendants.
Come to the page 58. Yes. Read in the middle. Plaintiffs are the absolute owners and possessors since long time, about 50 years. They are continuously at present cultivating the same scheduled property and landlords. According to the plaintiffs, defendants, they are in possession of the property. Can this court is having any power to accept that your own contentions is gospel? You are right now. Therefore,
page 73.
Therefore,
Page 73.
Page 73. Yes.
This is an application filed by the plaintiff. Seeking an appointment of advocate.
That is a different issue. Advocate commissioner is not having any right to.
Note of physical position.
That is a different issue.
But only
In the application, they have stated anywhere else saying that you are in possession in application filed by the advocate commissioner.
But application was filed on the basis of the suggestion given to Peter.
Whatever may be.
During the court of process.
That is purely civil disputes. In the application filed by the advocate commission,
That is
court has given any finding saying that you are in a possession.
Since I am in possession, I have requested the commissioner to be appointed and investigate to visit the property.
There are two things.
And kindly see my
One is no. There are two things. One is dismissal of your petition. Other is for issuance of notice. What is that choice? Your choice.
Notice.
There are two things. There are two things. If you want any interim direction, only after notice to the other side. Or else I will dismiss the petition saying that it is purely civil litigation.
Only my request is that also made him as in person because actually.
Notice, you take out notice to everybody. Yes, the petitioner is permitted to take out personal notice to the respondents 4 to 9.
Who is the not inspector in person?
Whatever may be, whatever, you take out personal notice. Respondents 4 to 9 and file proof of service. List this case on 28. No,
Let him not interfere.
no,
If I'm-
no. I'm not supposed to grant such an order in a 226 jurisdiction. Repeatedly, Supreme Court is cautioning the High Court. When it is an issue relating to the possession or say disputes, you should restrain your power.
Only lordship permission, I would like to say one aspect. Only one aspect. I filed an application seeking appointment of advocate commissioner to visit the two scheduled problem. Not agreed by that, they prefer division, they did not get any order. In the meantime, if commissioner visits, truth will come. That mother who is in possession of the power. Only to.
Let them visit in the absence of the stay granted by this court. Commissioner is always entitled to visit.
Commissioner should notice to the defendants along with the advocate. They reported that the advocate went to Assam. They are not.
That is totally a civil
They are-
issue.
they are not-
See, when you, Mr. Kumar, you are also regularly a civil lawyer being appearing regularly in civil courts. He instituted a suit seeking with declaration, consequential perpetual injunction, claiming to be for your rights and adverse possessory rights. See, Advocate Commissioner has been appointed to note down the physical features of the property. Questioning the Advocate Commissioner's appointment in IAA, they filed a revision. There was no order. You request Advocate Commissioner to conduct the survey, that's all.
But I'm doing that.
Do that. Not invite police into the litigation. Do that.
They are interfering, but so in order to.
Let the notice may go. Let them come before court. Short date only given. Yes.
Item number 30, Mr. Chandrasekhar.
Yes, Mr. Judge. Yes, the petitioner seeks permission. Petitioner seeks permission to withdraw the petition with a liberty to avail the remedies as available under law. Liberty is granted. The petition is dismissed as withdrawn. Yes.
Item number 31, Mr. Surya Mahendra.
May I please, Your Lordship. I'm appearing online, Your Lordship.
Yes, yes.
Agreed by the action of the respondent number 3, Your Lordship, not closing the rowdy sheet, wherein during the pendency of the crimes, Your Lordship, the said rowdy sheet was opened. And however, Your Lordship, in one of the crime, the petitioner was acquitted, and other two got compromised and closed, Your Lordship.
Yes.
And there are no other cases pending against the petitioners as on date, Your Lordship.
At the request of the learned government pleader for filing counter affidavit, leaves this case on 11/12. Yes.
Much obliged.
Item number 32, Mr. Nathur Bhaskar.
Yes, ma'am. Your voice is little low. Use the microphone. Yes, what is your case, madam?
The respondents, Your Lordship. We have approached respondent filed to register case against Your Lordship.
Read your complaint, page number 24. ఎలాంటి అనుమతులు లేకుండా విపంచి చిట్ ఫండ్ కంపెనీ పెట్టి నన్ను సబ్స్క్రైబర్ గా చేర్చుకొని వై హావ్ జాయిన్డ్ యాజ్ ఎ సబ్స్క్రైబర్ when there is no permission being obtained by the person who is running the chit fund company. It is your at own volition you have joined as a subscriber of chit company. Why you have joined such a company when it is not legally registered with any of the after obtaining necessary permission for the registrar of the companies or registrar of the societies registering the chit fund company? Nobody is requested you to join in a chit fund company. You have intentionally, your own volition, you have joined. Then there are disputes, face it. Do you want to lodge a complaint? రామకిషన్ అక్కడ లావాదేవీలు సంప్రదించాను కానీ వీరు నాకు డబ్బులు ఇవ్వకుండా మోసం చేసినారు. ఇటు విషయమే నేను వాళ్ళని సంప్రదించగా ఇస్తాం అంటూ నడుపుతున్నారు. నడుపుతూనే ఉంటారు అట్నే ఇస్తాం అని నడుస్తానండి మీరు అదే అలాగే. కలిసి ఒక పథకం ప్రకారం కుట్ర పండి నా దగ్గర ఇతర ప్రజల దగ్గర చిట్టీల పేరుతో సుమారు 50 కోట్ల రూపాయలు వసూలు చేసి కంపెనీ మూసివేసి దొరకకుండా బ్లాక్ మెయిల్ చేసి yes, what do you say? Why you have not registered a case under the Depositors Act? Get instructions. Yes, we will see. Yes, list this case for instructions on 28/11.
Item number 33, Mr. Ashok Kumar.
Why it was urgent?
the land of the petitioner is acquired, then the entire extent of the land does 1 acre 30. This Malad, the plotting was after grading of the plotting, the petitioner purchased some plots Malad.
753 square yards. 500 square yards was already acquired by them.
500 square yards and laying a road, electric road was laid. If no payment compensation was paid, and there are drainage as Malad to the land of the petitioners, even in the
When the drainage lane was there, you forget about the counter, first you start. No, forget about the counter, first you satisfy from your affidavit.
Yes.
When the respondents laid the drainage lane?
have,
What is that action you have taken when the respondents are laying a drainage lane from your land?
we have approached them Malad to seek the compensation.
Forget about it. You have approached now this court. What prevented you to approach this court when the respondents without acquiring your land are laying the drainage lane?
Lord, this GO Malad for laying up, for binding of the code is issued in 2013. You have to put 500 page 34.
Page?
34.
Yes.
Soon after,
See, Mr. Last occasion, I specifically put a question to you to refer page number 13 and show me that what is the page number 13 of the permission being granted by the Gram Panchayat.
Yes.
Show me what is that extent you have obtained the permission. And you said on that day, you will get instructions from your client. That was transpired.
Fine.
Why you are arguing the case once again? Do you mean to say that this court is not remember anything else? Last occasion I referred to you, page number 13, when you said that the construction is being carried on you by the subject land, but after obtaining necessary permission from the Gram Panchayat, I instructed you to refer the page number 12 of the Gram Panchayat permission. You referred, and then you said that in plan the extent has been mentioned. Then I said that show me the extent being, and you said that I will get instructions, update instructions from the client. That's how the matter being adjourned. I don't know. How can I know? Show me from the permission being granted by the Gram Panchayat. Why should they? It is your case. Why you want to produce the records of the respondents? It is your case. You have to satisfy this court that prima facie you are having a case. I can't rely upon the discrepancies of the counter affidavits being filed by the respondents, and you can't rely upon it is settled law. You can't rely upon the discrepancies of the counter affidavits being filed by the respondents or the loopholes of the counter affidavit. It is settled law, and you satisfy me from your own permission being granted.
Here, the question is not regarding the permissions being authorized or I have obtained permission. The question here is, my lord, prayer is, my land has been acquired to an extent of 500 square yards, for which no compensation.
And how can I decide that your land is acquired in the absence of the respondent saying that your land being not acquired? It is a disputed question. Go before civil court, file a appropriate suit that you are a owner for the 203 square yards, which land has been illegally acquired by them. They are not only liable for payment of compensation, they are equally liable for initiation of the land acquisition procedure. Go and start for a declaration in the absence of anything being mentioned in the permission being granted by the municipal Gram Panchayat.
Permission given by the Panchayat Raj cannot decide, my lord, how much land is acquired by the.
But who has to decide?
Here, my lord.
Can this court is having power to decide that you are the owner for the 203 square yards that was acquired? Therefore, what is the extent you have Therefore, I put a specific question on you that what is the extent you have constructed from the land which you have purchased? You said that they have obtained the permission for this extent, but you have failed to establish before this court that what is the extent the construction is being carried out.
I agree, my lord.
You have agreed last occasion. Mr. Counsel, you are saying that you purchased the land to the extent of 703 square yards.
Yes.
Out of 703 square yards, according to you, 203 square yards construction is being carried out and 500 square yards illegally
It is
acquired by them. I said to prove that you are constructed only 203 square yards, show me the permission of the Gram Panchayat. You referred page number 12. Page number 12 and 13, which refers to the permission, there is no extent at all mentioned. How can this court will come to conclusion that the construction is being carried on by you is only to the extent of 203? Why not it is 703 square yards?
There is no extent mentioned in the transcript. This will be conducted with.
No. I am not here. I am not here to suggest somebody to do something. It is for you to establish that you are owner of the property.
can put in the record, how much extent of the land is required? What is the extent of earlier it was-
And you are the owner of the property and you are not in a position to produce what is the extent you have proceeded for construction. I am not saying about the road. What is the extent your construction is being carried on? I am not saying about they have not acquired the land. You said that to me, remaining extent you have constructed. What is the extent you have constructed? Show me without mentioning the extent, without mentioning the boundaries. Can any of the local authority will grant the permission? It is a manipulated permission being obtained by you. Otherwise, show me the extent if it is a legal permission. Can show me the law or the municipal law or the local law which says that even without mentioning about the extent of the land, the permission can be granted by any of the local authority. Is there any such provision, Mr. Bhargav? You are appearing for the municipal court. They can grant the permission in some other lands. There is no dispute. But think it is unless there is some extent being available, where is the question of they are granting building permission?
Page 47 of the counter file.
Why you are relying upon the counter? Why you are not establishing your case from your own material papers?
Sketch plan. They have filed a sketch.
Page number?
Page 47 of the counter.
Yes. Yes, show me.
The sketch plan. The road line. This is a road. Four-lane road. To the top mirror, to the right side, there are the temporary sheds mirror. Sheds 1, 2, 3, 4. The right side, you have to find that the reference portion mirror. I would like to point out the reference portion. Petitioner's temporary sheds. It's marked in the red. There are existing structure of the 500 feet, 50 feet from the center of the road. This is the center of the road, pink portion. Thereafter, the third reference is completed set drain work. To the right side of the inside mirror, you are not supposed to find that the underlying portion is difference number 4, the excavating and digging from the side of the drain work. If you see the dotted lines, this dotted lines is going from the right to the left. Where is the property? The petition has been affected.
No, is there any stay granted by this court? Therefore, the road has been, structure has been raised by them occupying your property or not would not be clear from the sketch. They say yes, according to them, you have encroached the road margin portion into the 50 feet. Now, have you questioned that? And is there any stay directing the authorities to not to acquire the land without permit? Not, is there any?
I have not even
Yes, what do you say, madam, about the plan?
There is no damage to the structures. And similar page 8 of my counter page 41.
Sorry to say, Lord, it's nothing but
Come to page 46 of the counter. First, come to page 46. Yes, read that.
I am hereby submitted that the important R&D road is passed through Kosigi town and that recently the junction improvement work 4-line was started with Kosigi town limits. For that, we found that among the unauthorized encroachments are directed from kilometer 41, 42. The execution of the work, these are disturbing a lot. And due to this, the work will be checked up in some extent, and it is necessary for the eviction of the encroachments as early as possible. But through the execution, hence I request the executive officer to take all the illegal encroachments.
It indicates that they have followed the procedure as contemplated in law. They have not taken any action of removal of illegal encroachments. Therefore, the assistant executive engineer who addressed the letter to the executive engineer in specific terms stated there are certain encroachments being found on the road margin. Therefore, those are required to be removed by following the due process. Please do that. That shows that they are following the law. How can you?
No, they have given me any specific notice.
I don't know whether you are whether you are an encroached portion or not. If you are an encroached portion, they would have been given a notice. If you are not encroached portion or voluntarily, if you have removed your structures, where is the question of they are issuing any notice?
Structures. But in fact, the facts clearly show.
I will dispose the writ petition. I will dispose of the writ petition directing the respondents to take into consideration of the map prepared and page number 47. If the arbitrarily, if the alleged encroachments, if any being owned by the respondent, the petitioner being removed, to take appropriate action in accordance with law.
There are grievances regarding the compensation.
No, I don't know who has to pay the compensation unless your rights being determined that you are owner of the property. Where is the question of amount being compensation being paid directly? And where is your sale deed? Show me first 7 or 3 square yards.
Stated at page 16.
Page
16. Start with page 16.
Page 16. Yes.
Page 20 is the schedule.
Page
20 is the schedule of the property.
yes.
మొత్తము 703.74 square yards. Survey number 1813. Plot number 11, 10, 9, 8, 7.
Show me the permission obtained from you from a conversion of the agriculture land into non-agriculture. Show me the permission granting a layout, approved layout. Show me. Therefore, how can I determine all these things? There is no permission for conversion of land from agriculture to non-agricultural use. There is no permission for even obtaining a layout for the plots. Then how can you purchase the plots? This plot number 11, 10, how can you? Therefore, you are right in saying that this court cannot go into all these aspects.
Yes, court can go in. Whether I am the owner of the property.
How can I decide? How can I decide that you are owner of the plot number 11, 10, 9, 8, 9 in opposites? So registered document, does it confer any title? Registered document, does it confer any title in the absence of the layout being produced by you? Show me a layout that in this layout.
It is a registered document.
So registered document, does it no, registered document, does it confer the title?
In fact,
I don't know now. I only know that a person who is having a title, he can transfer the title. I don't know registered document. If you want, I will give at least in advertising judgments of the Supreme Court saying that registered document does not confer any title unless the transferee is having a title to transfer the property. Otherwise, tomorrow onwards, everybody says that he is the owner of Charnar and HIGHCOURT also. There are so many sale deeds. See, show me, I am only asking, show me the approved layout wherein these plot numbers are mentioned. That's all. I will dispose of itself that you are owner of the property. Istamana plot number leskoni registered document undanti itlane. Show me the authorization of the law. That is
page 22,
page
22.
Yes.
Here the plotting.
Are mallakki anto. Even ee sale deed kuda include chesindi. నీ దృష్టిలో పోసి నాకు ఏం తెలియదు అనుకుంటున్నావులా అంటే show me that this is a plan enclosed to your sale deed. I am asking the plan being enclosed, the plots of the approved layout.
Layout copy is not required.
Produce the layout. I will say that you are a owner having purchased in a plots in a layout approved by so and so. Panchayat also is liable for granting of layout as per the rules framed under the Gram Panchayatis Act 1972 building rules. From 1972, I am saying. How can I determine? You are not saying. How can I determine in a sale deed of this nature that you are owner of the property and the respondents are liable to pay compensation?
Respondents are not liable to admit the property.
Where they admitted, they your title. Show me counter affidavit. Show me why you prove your case, why you are laying upon the respondent counter. They may say that you are owner of 5 acres, motam entire road. Does it binding on this court? According to them, work was completed and BT Central Media work was completed in entire reach from so and so, and side drain work is in progress. The reach from so and so side drain work was constructed at 50 feet from the center of this road. The side now come to next paragraph.
work was started.
Where they admitted, show me that you are owner of the property.
They have not denied it. In fact, they have to specifically deny my.
Not necessary. It is your affidavit. You have to prove your case.
But here the question is not regarding whether I am the owner of the property. The sale deed shows that I am the owner of the property, which has not been denied by the.
Sale deed does not confer any right of ownership. You are not following the law. The registration does not confer any ownership in the absence of you being purchased the plots in approved layout.
My owner is not having any transfer. He title to the property that they.
I don't know. I don't know all those things. There are so many sale deeds being registered. You are not aware about the law. I was 8 years government paid for revenue. How many sale deeds being registered? You are not aware. Even government land, assigned lands, surplus lands, also sale deeds being registered.
Paying a lot for
Because under rule 56 of the registration rules, sub-registrar is not having any power to look into the contents of the documents, and he don't have any power of even whisper to a state for registration of the documents. Is only a post office duty is doing, he can register the document. He never have any power to look into the contents of the schedule of the property. That is the registration. Show me where they have agreed in the, stated in their counter affidavit that you are owner of the property. In fact, they said, come to page para 10. It
is not true that the respondents have taken 500 square feet without paying.
What does it mean? It is not true means it is not almost to denying. You yourself said that they are not denying. You said just before you said that there is no denial. See, read next line. It is a summary proceedings. We are here. I can't decide your title in the red petition. You read the next line.
Respondents not occupied any private land for construction of the road.
What does it mean? It amounts to admitting that you are owner. The respondent not occupied any private land for construction of road means what?
Not only violate any private land, any other property.
What is this argument, Mr. Counsel?
But in fact, there is a property was existing in the curve, but it has been acquired. The state road has been laid, and even with the photographs, it shows the state road.
Yes, that is your argument. Yes, right. Right. There is this petition has been filed, praying this court, seeking following belief. The petitioner claims to be
Starting now. I've got two lines it will get.
Petitioner claims to be registered on property to the extent of 703.74 square yards. Yes. Yes. Who are you? I know that you are a license holder. Why you need a arms license now? Yes. 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 So what are the reasons for this year they are not granting? 307 against whom? Yes. Yes. Yes, they have given reasons. How can you say that no reasons they have given? Read paragraph 2 after the tabular form. Yes. Yes. That is a ground. No. Exemption is not granted to the above license holder from depositing his weapon in view of Telangana State Legislative Assembly General Elections.
TSHC submitted representation to the morning. Is a page 17. Narrated the incidents and about the legislative petitioner. Page 17 the representation. Page 19. The representation
Says, what are your instructions?
You have got clear exemption when all the during the concept of having license, you never restrict the weapon. He's only for using for a
So why you are passing on these instructions? Yes, what is your case?
The petitioner was an advocate and later on he became an active politician.
All advocates are the politicians. There are so many advocates in the parliament. And Mahatma Gandhi also advocate. Jawaharlal Nehru also advocate. Sardar Patel also advocate. Chidambaram also advocate. There are so many advocates who are the politicians. It is, yes. It is our right. Yes. And 90% of the participants in the freedom struggle are the advocates.
In 2018, he was not into active politics. Later in the year 2019, he became an active politician and he also contested
ZPTC elections.
Yes,
he lost in a marginal vote.
Yes. And this was not done arbitrarily. The screening committee, based on the report of the screening committee, they have.
What is the report of the screening committee?
Can we see the report?
See, what is the basis for the cancellation? Have you conducted any?
Yes,
have you received any report? There is no threat perception to the petitioner.
Yes, there is no threat perception. And
read the relevant portion.
Can we see the paragraph of page number 2?
Come to page number 3, third paragraph directly.
Most important to submit the responsibilities of Kochara Magistrate. Discrete inquiries clearly reveal that the house of the petitioner arms license holder is very next to the polling location of NP, UPS, Sondariguda village, and there are polling stations. Number so and so, and these are very critical polling stations. It is further revealed that the petitioner arms holder contested the ZPTC elections 2019 from Gatnesar and Congress. Also,
That case on Congress party and he was defeated and it is known that he is in active political activities and he was residing in Apsiguda as well as Chodariguda, that case on Mandal. So what is wrong in it? He's an advocate, what is wrong in it? He's a politician, what is wrong in it? Is there any involvement of the petitioner subsequent to obtaining arms license?
That the weapon may be misused, that is the only.
As he misused the weapon from 2012 to 2023, almost 11 years. At any point of time.
He has not misused the weapon, it is only for purpose of
election. It is fortune for him is that the polling stations being now located to the near to the residence.
Yes,
he shift the polling station saying that there is every possibilities of petitioner being involved.
May make a submission, and this is the appealable order.
What is appealable order?
Under the Arms Act, this order, this reviewed order can be appealed before the government.
What is the purpose of
Election Commission?
Page number. Is there any directions issued by the Election Commission saying that the persons who are holding the arms license is required to be reviewed during the election season? Produce me that a circular issued by the Election Commission, then we'll agree.
It is a practice.
Forget about the practice. There are so many types of practice. Is there any specific instructions being issued by the Election Commission saying that you please renew or review all the arms license in twin cities of Hyderabad or in entire Telangana because of elections?
Because of elections, the district collectors are authorized to send notices to all the license holders to deposit the funds. Yes. And only exemptions are sought in specific.
Then why you have considered for earlier 3 occasions for granting an exemption?
There was then also dispute inquiries were conducted. Then there was no threat perception. Now it is
there was no threat perception. Since the crime register against the petitioner is pending from 2018 onwards, 307.
Since he is actively in politics now and
he contested the elections in 2019 ZPTC elections. ZPTC elections, according to my knowledge, recently no ZPTC elections being conducted. It was conducted in the year 2019.
In this case, the possession of arms on this person in this during the election time.
Why you want to take a risk of having a weapon at the election time?
Now we can see police protection for his life.
Are you ready to provide the police protection?
He can make a
what is the guarantee that you will provide the police protection when he is not having a threat perception to his life? Question of granting police protection does not arise under the GOs.
This exemption was not given in the interest of people, in the interest of peace and tranquility.
Where you have stated the reasons that the interest of peace and tranquility, his involvement is there. Because reasons has to be satisfied to the consensus of this court. Give me the reason. You are either in the instructions or in the order. Because as for the Mohinder Singh Gill case, you are not supposed to enlarge the scope of the impugned order. You are aware that you are not supposed to travel behind the scope of the impugned order. You must contain all the reasons must contain the impugned order. You should know the reason. This is the reason. Your reason is elections. Is there any circular issued by the Election Commission of India saying that please review all the arms licenses issued to the persons and whose lives are in danger also you review and take the custody of the weapons?
The proceedings of the screening of the ballot will be
Right. The interim order granted by this court dated the Learned Government period seeks time to file counter affidavit. The interim orders granted by this court is extended. When you want to file counter affidavit? Interim order granted by this court is extended up to 4/12/2023. Meanwhile, Learned Government seeks time to file counter affidavit. Interim order granted is extended. నువ్వు బడే మాట్లాడతావా నువ్వే అడిగినావు కదా కౌంటర్ ఇస్తా అని ఫైల్ చేసినాక మళ్ళీ మూవీ అర్జెంట్స్ ఉంది ఈ వెపన్ తోటి మిస్యూజ్ చేస్తుండినా మీరు ఇట్లా ఆర్డర్ ఇచ్చారు ఎలక్షన్లు అయిపోయేదాకా కానీ ఆయనకి ఎలక్షన్ థ్రెట్ ఉందని ఆయన అంటున్నాడు.
Here the polling booth method. It will
You know,
document
I
on the
I only put a simple question. Is there any specific direction issued by the Election Commission of India? Directing you to please review the licenses being granted under the provisions of Arms Act 1959. If such a direction being issued by the Election Commission of India, move tomorrow itself, vacate the petition. Day after tomorrow, it will be heard.
posted for tomorrow, but I'll get details so that the things
Interim order granted extended for a period of 2 weeks until ground Peter seeks time to file counter affidavit. Meanwhile, yes. 2 వారాలు వేసేసి చూసేద్దాం. 2 వారాలు ఎలక్షన్ ఇంకా 30వ తారీఖు చాలా రోజులు. అట్లా నువ్వు కావాలంటే ఆ రూలింగ్ పార్టీ అంటే తిరిగేటోళ్ళు చాలా మంది జోగుల చేతులు పెట్టి దొరుకుతాయి. But if they filed a counter affidavit stating that you are involved in any of the criminal case, you are not entitled. That is your version. We don't know. You file a counter affidavit immediately and vacate the petition. It will be taken up immediately and next day. Make a mention about saying that there is the danger to continue allowing him to carry the weapon. We will vacate the order. Yes.
Past door matter item number 30. Sayyid Nazma.
Yes, madam. Yes.
Number 1523 this matter has been drawn the 19/6/2023 on same day however respondent police has sent a notice to the additional minor by stating that we have closing this party within an reachable stating. After that they said that they filed a final report in the lower court minor. We filed a protest petition in lower court minor. But after that we came to know that the protest petition has been unnumbered return minor by stating that final report that there is no such final report has been submitted by the respondent. So now we are filing the
Yes, what do you see? Those means you are not supposed to close any complaint. You are supposed to file a report on the file of the concerned magistrate. Investigation report. And according to the petitioner, when they file a protest petition that was written saying that no final report has been placed on the file of the court. Instructions system is other than the should apply your mind to the instructions being issued by the respondents. Why? They are only asking what is that, and they are saying that the funds information being furnished to this court in WP number 15223 of 2023, stating that they have filed a final report on the file of the magistrate. Why you have submitted such a false report, false information to the court? Come to paragraph 10 of the affidavit. Read the relevant portion. Strong words you use in affidavit law. This act not only unethical but also undermines the credibility of the police department. At least, anyhow, everybody knows that you don't have any credibility. See the next sentence: judicial process. How can you make?
Last year they put up for instruction and the final report minor. And matter is posted on 7/11 minor. That's very morning.
That is the reason why repeatedly I am cautioning you. Don't rely upon your officers unless you make an examination of your own records. Now they will come and say that we never instructed the government leader or AGP to report like that. Then you are liable for the contempt for misrepresentation. Counter in the mala tapicchukoniki adanta.
Yes, I have let them file the details on the regarding this.
You want to file a counter affidavit? Yes. At the request of the learned government leader, list this case for filing of counter affidavit on 4/12/2023.
Item number 34 to 37.
Yes, Mr. Durga Prasad. Yes. Special GP? Oh. ఎందుకు సార్ ఆయన ఎక్కడికైనా వేరే దేశంకి వెళ్ళి రావాలనా? అవును, బ్యాచ్ మ్యాటర్స్ నాకు తెలుసు, లిస్ట్ లో చూసిన నేను. ఏం కావాలి? ఎస్ మిస్టర్ దుర్గా ప్రసాద్.
Filing the counter. These are covered by judgments earlier. Earlier, when what happened, the government issued a GO giving right to one agency. We filed questioning the GO. GO was on the status. The order copy also filed with us. They took time last edition. All these are covered by the judgment of this honorable court. It was confirmed. Now we are at the point is our theatre sale of tickets is given to some third party agencies.
See, this is a matter of 2017. Where is the question of you are filing counter now? Where is that order? This is an order of Justice Ramesh Ranganathan. Yes. Page 18.
Yes.
This order was confirmed by the division bench. They filed an appeal against this order. What is the prayer in your writ petition detailed?
Again, the new GO issued that was questioned.
But they have not filed counter in the new GO. Counters are there in our record at least.
No counter.
This GO issued subsequently is impari materia with the earlier GO.
Initially,
same GO.
One GO issued giving agency, one agency. That was set aside. Subsequent after elections, the new agency was formed and GO issued.
You are having a stay in your favor.
Yes, sir.
You enjoy your stay.
Right, won't take much time. Necessarily. Only
Yes, what do you say?
if there is any change or not, they can say.
What instructions you will get? It is listed on the last occasion also. 9/10/2023 at the request of Leonard Special Government Pleader appearing for the respondents, list these cases on 6/11/2022. Yes, ready. These writ petitions, batch of writ petitions are pertaining to the year 2017 listed. When the cases were taken up for hearing, the Leonard Special Government Pleader
Item number 38 is the this part is correct.
Yes, post along with this.
The lordship will grant the same order earlier.
What order?
Even counter has not been filed in this matter.
Not necessarily, it will become along with the one. All batch cases. You said it is a batch case.
Item number 39. The C-Rickshaw.
Is a mistake on the part of the court officer or your the Deputy Commissioner, Prohibition and Excise, Hyderabad Division, Hyderabad Division. Everybody, every respondent you have shown as in Hyderabad Division.
Page number 5, order.
Yes. That is mentioned by you. That is not mentioned by the court. Hyderabad Badala, Hyderabad Division. Petition allowed for the legislative. Legislated, the petition is allowed. Office is directed to carry the necessary correction and issue. Yes.
Item number 40, Mr. Rajnikant Bala.
May please your lordship. Lord, in this case, I am seeking withdrawal of petitioner number 43 in the writ petition. Lord, out of the entire batch, only petitioner number 43 seeks
Why can't you
withdrawal of the writ petition.
Why this piecemeal procedure of withdrawing one petitioner?
No, because he has sold away the vehicle. He is in.
Rajnikant Jala, you have filed a common affidavit deposing on behalf of all the petitioners. If one petitioner seeks to withdraw the writ petition, it amounts to he is also deposing on behalf of all other petitioners. Therefore, I will dismiss the writ petition as withdrawn for all the writ petitioners.
No, lordship may kindly consider.
For this petitioner also, very same petitioner has filed a common affidavit at the time of filing of batch on behalf of batch of writ petitions.
No, the first petitioner has filed.
Is there any separate affidavit on behalf of this writ petitioner?
The first petitioner, Milord, has filed sworn in the affidavit on behalf of all the petitioners.
Therefore, he has deposed on behalf of this petitioner also.
Now, Milord, my respectful submission is, Milord, he is if he has fell in heavy debts, Milord, your lordship knows those who are not fit for any other field in this work, any other work in this society, they come to transport field. Milord, now he is in a very peculiar situation. Milord, he wants to sell away the vehicle, Milord, and make the payment.
నువ్వు కొత్తగా చెప్తున్నావు రజనీకాంత్ జాలా, ఇంతకుముందు అనేది ఎక్కడ పని లేకపోతే అడ్వకేట్లు అవుతారని నువ్వు రివర్స్ లో చెప్తున్నావు ఇప్పుడు.
Your lordship knows, Milord. Lordship may kindly consider, Milord.
మమ్మల్ని అనేటోళ్ళు మేము ప్రాక్టీస్ చేసేటప్పుడు
as filed separate IA, Milord.
This petition for the reasons stated all over the case.
Only petition number 43, Milord.
IA allowed. IA 1 of 2023 filed by you is allowed.
Deeply obliged. I am obliged to your lordship.
Item number 41.
When case pending. Post main writ petition on 1812. Yes. This is that public prosecutor case. Yes. Are you? They are relying upon Justice Ramesh Ranganathan's judgment, if I rightly remember.
My friend also argued on that matter.
Enroll with me on service. You want an order on merit or you yourself resign? You want an order on merits? I will dictate.
They argued the matter. Further argument, I request
When you want to argue? Before elections, why you want to change is you will consider it after elections. Post this writ petition.
Months and please, I gave it to the argument with me. In this particular action.
after elections.
Is this case for orders on 4/12/22?
What is
The learned counsel for the petitioner. The learned counsel for the respondent. Which respondent? The learned counsel appearing for the respondent seeks adjournment. In the request of the learned counsel for the petitioner, respondent list this case for orders.
I want to argue this matter.
ఇంకేముందని ఆర్గ్యూ చేస్తా ఉన్నా ఈవెన్కు ఇంకో 15 రోజులు ఆడ కంటిన్యూ ఇవ్వమని వాయిదాలు ఇస్తున్నాం. ఇది నాట్ దట్ యు ఆర్ హ్యావింగ్ ఏ గుడ్ కేస్ ఇన్ దిస్ కేస్. This case is clearly covered by Justice Ramesh Ranganathan judgment, and your client is not fit for appointment as an additional public prosecutor. Because it is an election time, there are so many cases being filed. There must be representation on behalf of the state to have a additional public prosecutor. That is keeping in mind of that This case was adjourned to that date. Yes. Parted for orders.
Number 42 and 43.
నువ్వు నా చేతిలో మీదకి వెళ్ళిన గేమ్ చూస్తున్నావు ఎందుకు చూద్దాం ఏమైతుంది దాని పరిస్థితి.
Again, I have to ask.
If you are having a case, never fear about arguing of the matter. It is an occasion for you to argue as many as times. Yes, yes, Balamon Reddy, what is the matter?
Directing the respondent to take enforcement of law. The unofficial respondent files a contempt against official taking action of removal of enforcement of law.
Is a contempt case? Yes.
Taking action.
Manik, they submitted that the land council appearing for the petitioner, he requested for some adjournment, Mr. Janardhan Reddy. Yes. Both are related, Mr. Both are related, connected. Yes, list these two cases. When do you want, madam? List these two cases at the request of the land council for the petitioner, contempt. Yes, the land council for the petitioner in CC number. CC number 1340 of 2020. These two cases on 28 level.
Item number 44.
Excise cases. Execution of the bond. Yes, what do you say? You have followed the procedure. Read the impugned order. Yes, what do you say? See, they have followed the procedure prescribed under section 122, 1B of the CRPC. They have given an opportunity, they issued a show cause notice, you have submitted an explanation to the show cause notice, which is referred in impugned order as reference number 6. అది కాదయా నువ్వు తీసి చదువు నువ్వు ఇచ్చిన ఇంప్యూగ్న్డ్ ఆర్డర్ పేజ్ 13 పేపర్ చూడకుండానే నువ్వు ఆర్గ్యూ చేస్తే ఎట్లా నువ్వు మిలాడ్ అంటాడు మళ్ళా ప్లీజ్ కమ్ టు రెఫరెన్స్ నెంబర్ 6 notice issued by this court under section 122 1B of the CRPC date served on 25/1/2023. What is that you are serving now? Counter affidavit? Huh? Where is the order passed under section 117 of CRPC? See reference number 3. Therefore, the judgment passed by this court on WP number 9124 is not applicable to the facts of this case. The case was allowed by this court on the ground of no final orders have been passed under 117 CRPC before issuing a warrant of arrest under section 122 1B of the Act. Now here it is a case, they have followed the procedure. They have followed the procedure of passing an order under 117 CRPC. They have communicated the final orders to you and the notice has been served on you. Enrolled and Rilla. 1/11/2021 to 31/10/2023. In view of the interim orders granted by this court, you have been released. Now, if I dismiss the writ petition, what will happen? Yes, definitely you have to go. When an order is rightly passed by an authorities, there is a question of see.
There is no reply submitted by
What reply? What reply? If you have not submitted the reply, what can they do?
They are not received any notices. That is, they just mentioned in the input order that is not due to serve to me.
Have you stated in your affidavit no show cause notice has been issued and no? Show me, read the relevant paragraph in your affidavit. Read, you said that you have stated, raised all these objections. Read the relevant paragraph. Have you filed your counter affidavit? File a counter affidavit. It is a matter of conviction for a period of 2 years. It requires to be considered elaborately with all evidence. File your counter affidavit. But Mr. Petitioner Counsel, they followed the procedure. పోవాలను ఇప్పుడు మటుకు దీపావళి చేసుకో తర్వాత చూద్దాం. They will say, they will file all your documents in support of your allegations counter. They will file now counter when it was served or all these things. If there is any loopholes in their counter affidavit, we will consider it. This case for filing of counter affidavit on 28/11/2020.
Number 45.
Same this case also. Yes. List this case on 28/11/2023 for filing of counter. Take number serious, Mr. Governor Peter. And you want to convict a person relying upon your impugned order for a period of 2 years under the excise offence for violation of the bond being executed under section 106 to 110 of the CRPC. And this is not a case of conviction even. It's only for violation of the bond being executed by the petitioner as per the chapter 8 of the CRPC. And you don't want to file a counter, you impose 2 years punishment for violation of the bond. You have to file a consolidated counter affidavit satisfying that the procedure being followed by you is. Yes.
Item 46, Mr. Mobilian.
Post on 28. Not post on 28. Yes, what do you say? This is allowed, that case, that where is that order? Page number 15. ఆర్డర్ కూడా ఉండే మనకు కూడా ఉంది సరే ఇది this court also passed some orders. Where is that order? WP number
647.
Yes, అదే పాచి. Yes, disposed of. జరాగు ఒకటేన్ కోటి.
Item number 47.
47 48. 47 అయిపోయింది కదా ఇప్పుడు.
46.
Yes. Yes, what is your case? Who is appearing for the petitioner? Right? Since they have filed a counter affidavit, he was held up in a second. Yes, list on next date. 1 week. Is this case on 2011? Next case also same. 2011. Yes. Where is the show cause notice? Page number? Yes. What do you say? 3 days. Violation of principles of natural justice. Allowed. Same order in complete. Yes.
Letter number 50, Mr. Mogli.
So that even 3 days time.
Yes, allowed. ఏం ప్రొసీజర్ లేదు ఏం లేదు. See, issuance of show cause notice. The minimum 2 weeks time is required to submit an explanation. 3 days time is not sufficient time and it amounts to violation of principles of natural justice. Therefore, I set aside the impugn notice and directed you to issue fresh notice and follow the procedure. Yes.
Item 51, Mr. Balamurthy.
Learned counsel appearing for the petitioner has submitted. The relief sought in this petition no longer survives. The petition has become infectious.
Item number 52, Mr. Sridhar Reddy.
Yes.
52 and 53.
Yes. Repetitions have become infectious. So what first you say on 52 it? How it has become infectious?
The lessons are being handled with the commissioners officer.
Yes.
What I want for is Victor Mandamus declaring that on the point not taking steps, not proceeding further, pursuant to local. No, yes, proceeding further. Therefore, move further out of the.
Both the repetitions. Yeah, WP number so and so is to the learned counsel appearing for the petitioner. Submits that the cause in the repetition no longer survives.
In view of the order passed on date 12/10/2023.
In view of the orders passed by the respondent dated so and so.
This what was certified. Memo dated 2/7/2022 of government. Back to
You exercise the revisional powers by the government. So what happened? What happened to the revision pending before the government?
Revision pending.
Yes, what do you say? How it has become infectious? Here also license is being cancelled. Oh. Disposed of. Stating what?
I have questioned the interim order passed by the revision.
He is entitled to file appropriate proceedings. I will say that in view of the cancellation, the cause in the revision pending before the government become infectious. Yes, sir, this petition has been filed. Questioning the memo issued by the first respondent. Questioning the memo of the first respondent dated 9/6/2022. List out. Entertaining a revision application filed by the respondent number, third respondent. List out. This court, while interim order stated so and so, suspended the orders of the government. This court, by interim order stated 17/4/2023. Suspended on the ground that the government is not having any power of review under section 64 of the Excise Act. List the pending adjudication of the writ petition Land Council appearing for the Land Council appearing for the parties have submitted that the licenses which are the subject matter of the revision pending in memo number 16541 oblique EX dot 2 bracket 2 oblique 2019 by 4 at a 9/6/2004 2022
same time without hearing a mail. Then collecting at the same time my bag.
Traffic challan.
Traffic challan. This is only a challan imposed on you.
That time MNC is going on there. In the case, I collecting my bag. At the same time, I am approached the lower court also. Then the court also sending the proceeding FIR.
What is that you want? What is that relief you are asking from this court?
I want to my bag. Then connecting my both ornament is there. The cost is
So diamonds కూడా ఉన్నాయా? Only gold ఉన్నాను. So gold ఉంది. Gold items ఉన్నాయి. Diamonds లేవు. Cash కూడా లేదల్లా.
Yes.
What do you say? Why you have taken the gold ornaments of the petitioner? They denied that the collection of your bag from the gold ornaments. Yes, and what అయిపోతుంది కదా? You have to place substantial evidence on the.
Going the same days. Yes, sir.
ఇప్పుడు కూడా ఎలక్షన్లు వచ్చినాయి మళ్ళీ జనరల్ ఎలక్షన్లు. మళ్ళీ బ్యాగ్ వేసుకుని పో అదే రోడ్లో. No, you do one thing, whether the incident was happened or not, it is very difficult to establish before this court. This time also general elections has come for the assembly. Therefore, keep the with the very same bag, మళ్ళీ ఒకసారి వెళ్ళండి ఆ రూట్ లో. ఈసారి మళ్ళీ వాళ్ళు పట్టుకుంటారో లేదో చూద్దాం, మనం టెస్ట్ చేద్దాం.
They are not putting any bargains also. That's why at the same time, the house is there, school decide. That is going to residential areas.
I am asking you a question that what is that evidence you have placed to substantiate the contention that the police have taken a bag from your custody forcibly, wherein that bag is containing the gold ornaments? Very simple question. ఏ భాషలో అడుగుమంటావు చెప్పు, నేను అడుగుతా.
There is no response, sir.
ఎవరికి ఇచ్చినావు కంప్లైంట్?
కమిషన్ గారికి ఇచ్చాను, అక్కడ ఎస్ఐ పోలీస్ ఇచ్చాను సార్. బ్యాగ్ ఉంది, ఎవిడెన్స్ మరి ఎవిడెన్స్ చేసిన.
నేను అడుగుతున్నా కదా, వాళ్ళందరూ ఎందుకు బ్యాగ్ ఉన్నట్టు ఏముంది, ఏం వేసినావు ఎవిడెన్స్ అని అడుగుతున్నా. ఇది చాలానండి, ఇది ఎవిడెన్స్ ఎట్లయితుంది? అరే వాళ్ళు తీసుకున్నారు అని చెప్తూ చాలా తీసుకున్నట్టు ఎట్లయితుంది? నీ బ్యాగ్ వాళ్ళు తీసుకున్నట్టు ఏమైనా ఎవిడెన్స్ ఉందా? నువ్వు ఏదో కక్ష మీద వచ్చినట్టు నువ్వు కోర్టుకు పోలీసు వాళ్ళని సతాయించాలని కాదు, కోర్టును సతాయించాలని వచ్చినట్టు కనబడు. వాట్ ఈస్ దట్ ఎవిడెన్స్ యూ హావ్ ప్లేస్డ్? అరే మళ్ళీ ఎలక్షన్ అంటే ఎమ్మెల్సీ ఎలక్షన్లు అయ్యి 2 ఏళ్ల కింద అయింది, ఇప్పుడు ఎమ్మెల్యే ఎలక్షన్లు అవుతున్నాయి, మళ్ళీ సంవత్సరం తర్వాత ఎంపీ ఎలక్షన్లు అవుతాయి. అయితేనే ఉంటాయి అవి, దానికి మనకు సంబంధం ఏంది? Why you are unnecessarily troubling the ordinary citizen? They filed a counter denying you all your allegations in the affidavit. ఈ కోర్టు డిసైడ్ చేసే అధికారం ఉండదండి వాళ్ళు డినే చేస్తే. What is that evidence you are having? When you have submitted a representation to the Commissioner of Police, where is that representation? ఏది కంప్లైంట్ కాపీ చదవండి, ఏమి ఇచ్చారు? I have some gold, present market value of 50 lakhs worth gold bag లో పెట్టుకొని తిరుగుతున్నావు హైదరాబాద్ లో. అరే అడ్వకేట్లు భయపడతారు, ఫ్యామిలీలో 50 lakhs గోల్డ్ వేసుకుని ఎంత తీసుకోపోవాలంటే. అలా బ్యాగ్ ఉన్న బంగారం కూడా తీసుకున్నావు పోలీసు వాళ్ళు.
రిపోర్ట్ ఇస్తే రెస్పాండ్ ఇస్తామని చెప్పారు ఆ రోజు, మరి రెస్పాండ్ బ్యాగ్ ముందు ఇస్తామని చెప్పారు సార్.
You inquire into the complaint. ఏమని ఇస్తావు కౌంటర్? ప్లీజ్ రీడ్ ది కంటెన్షన్స్ ఆఫ్ యువర్ కౌంటర్ అఫిడవిట్. ఇవ్వండి. What happened? Already filed, you already filed details. చదవండి, కౌంటర్ చదవండి. Paragraph 5 చదవండి. The question of police seizing his bag is a concocted story, and the petitioner with a view to harass the police has made a false allegation. పారాగ్రాఫ్ 5 లా పోలీసులను అరెస్ట్ చేయడానికి కేసు ఇష్టం అని అంటున్నారు మీరు.
That is false.
వాట్ ఎవర్ యూ సే ఇస్ కరెక్ట్. ఒక పని చేద్దాం, ఇది దిస్ రిక్వైర్స్ లెంతీ హియరింగ్. ఐ విల్ పోస్ట్ ఇన్ ద మంత్ ఆఫ్ డిసెంబర్. ఫైనల్ హియరింగ్ వినాలి ఈ కేసు. పెద్ద కేసు ఇది, చిన్న కేసు కాదు ఇది. ఎందుకంటే నీ బ్యాగ్ వాళ్ళు ఎత్తుకుపోయారు, అందులో గోల్డ్ ఆర్నమెంట్స్ ఉన్నాయి, చాలా పెద్ద కథ ఉంది కదా స్టోరీ. సినిమా కూడా తీయచ్చు దీనికి. ఈ లోపల ఎవరైనా డైరెక్టర్ దొరికితే కూడా వాళ్ళకి ఈ స్టోరీ సినిమా తీస్తారు, రాయల్టీ వస్తుంది మనకి. ఐ విల్ పోస్ట్ ఫర్ హియరింగ్ దిస్ కేస్ ఆఫ్టర్ సమ్మర్ వెకేషన్, ఆఫ్టర్ December 15th అట్లా వేస్తాం. ఏమంటావు? ఏం కాలే, లాంగ్ ఏం కాలే, చాలా మంచి స్టోరీ ఉంది ఇది. బ్యాగ్ వేసుకుని పోయినావు, వాళ్ళకి బంగారం తీసుకోవాలి పోలీసులు, చాలా పెద్ద స్టోరీ. ఏ డైరెక్టర్ రాలి ఈ థాట్ ఇప్పటిదాకా. అదే 21 నుంచి ఇప్పటిదాకా వాళ్ళు పోలీసులు భయపెట్టిస్తున్నావు నువ్వు. మళ్ళీ చెప్పారు ఇలా కౌంటర్. నేను చూసి భయపడుతున్నామని రాసింది ఇలా 2-3 సెంటెన్స్లు నీ గురించి. అదే ఫాల్స్ కదా. We will hear little leisurely case. చాలా జాగ్రత్తగా వినాలి మీ కేసు. ఐ విల్ పోస్ట్ ఇన్ ద December 15th అట్లా చేస్తే ఎలక్షన్స్ కూడా అయిపోతాయి. అప్పటికి ఆ ఎలక్షన్స్ కూడా అయిపోతాయి. ఏవి ఎమ్మెల్సీ అయిపోయినాయి కదా అప్పుడు, ఇప్పుడు ఎమ్మెల్యే కూడా అయిపోతాయి. మళ్ళీ ఎంపీ ఎలక్షన్స్ వచ్చేటప్పుడు చూద్దాం. అదే మరి ఏం చేసాం మరి 21 నుంచి నువ్వు ఏం చేయలేదు కదా. What is that lower court case? You have not stated anything in the counter. Don't trouble unnecessarily ordinary citizens. ఉంటే ఇచ్చేయాలి. ఆ బ్యాగ్ ఏందో ఆయన గోల్డ్ పోయిందంట. ట్రాఫిక్ చాలా నేస్తే ఆయన 50 లక్షల గోల్డ్ ఎత్తుకోపోయారని పెట్టారు పోలీసుల మీద కేసు. I will do one thing. I will direct the commissioner to examine your complaint. అందుకే I will direct the commissioner of police to examine your application and pass appropriate orders in accordance with law. I will close the writ petition. ఆయన రెస్పాన్స్ ఇవ్వలేదని నేను ఆయనకు డైరెక్షన్ ఇస్తాను, మీరు ఆ కంప్లైంట్ పరిశీలించి తగిన చర్య తీసుకోండి అని. వద్దా? సరే December 15th కింద పోస్ట్ దిస్ రిట్ పిటిషన్ on December 5th. అందుకే వకాలత్ ఇచ్చేసిండు అడ్వకేట్. మీ అడ్వకేట్ ఎందుకు ఇచ్చేసిండు ఎన్ఓసి? అడ్వకేట్ల చేతిలో ఏముందండి డిలే చేయడానికి? కోర్టు లిస్ట్ చేయాలి కేసు. మరి ఆయన ఏం చేస్తాడు? ఆయన ఏం చేయలేడు కదా, కోర్టు లిస్ట్ చేయాలి కదా. మేము కూడా ఏం చేయలేము, రిజిస్ట్రీ పోస్ట్ చేస్తేనే వింటాం కేసెస్. అడ్వకేట్లు ఏం చేస్తారు? వాళ్ళ తప్పేముంది? నువ్వు ఎప్పుడు ఇష్టం పిటిషన్ దీంట్లో? మరి నీ చేతిలో ఎందుకు డిలే అయింది కేసు? ఇప్పుడు నువ్వు వచ్చి పిటిషన్ వేసినారు కదా ఇండిపెండెంట్ గా, ఎందుకు డిలే అవుతుంది కేసు? అదే మరి మళ్ళా 2 నెలలు టైం ఎందుకు అయింది మళ్ళీ కేసు? అడ్వకేట్లు ఏం చేస్తారు డిలే అయితే? దే ఆర్ నాట్ రెస్పాన్సిబుల్ ఫర్ డిలే ఆఫ్ ది కేసు. ఎస్, కాల్ ది నెక్స్ట్ కేసు. December 15th రండి. Yes, what is? Yes. Pleadings are completed? Page number? Yes. Yes, this is with regard to 3. Who is appearing? Have you filed any counter affidavit? Judgment of?
meters distance is not that, and it's direct. But in fact, the same.
I said last occasion there is a judgment of privilege.
Page number.
See, you survey a copy of the counter affidavit to the petitioner. I will take up on Monday. List this case on Monday. It is clearly covered by the division bench order. Let them file a counter affidavit, we will consider. List this case on Monday.
Number
Me good. Yes. So you are appearing for the petitioner. Who is appearing in item 65, 64. Yes.
But I am appearing for the petitioner in item number 66, Milord.
Yes. What do you say?
But item 65, but 2 members claiming to be the members of trust. They filed a petition.
Mr. Bhanu Prasad, the petitioners appearing in item number 64, 65, they are requesting for some time.
Milord, they request till December 25th, Milord, like that. Even before the vacation, I requested Lordship wanted to decide this matter on today. Lordship may grant short adjournment if they are asking for an adjournment.
Yes. This case on 2011-2023 at 2:30. At 2:30, I posted on 2011.
Yes, Your Lordship.
And it is made clear at the request of the learned counsel for the petitioners in petition WP number 7387 of 2022. The matter was the this case on 2011-2022 at 2:30 p.m. And it is made clear to the petitioner that no adjournment will be granted on that day for any reason. Yes.
I'm obliged.
Item 68, MD Murtuza Ali Farooq.
Yes, who is appearing for the petitioner? Who is appearing for the petitioner? Yes, who is appearing for the respondent? Yes, why you are not appearing? The accused number 2 and 5. When they are filing a criminal petitions before this court, how can you say that they are absconding and they are not available for arrest? When they are filing the criminal petitions and when they are serving the copies on other side, it is a sheer abuse of your position as a. So, applications are pending on the file of the court for issuance of NPWs. What are the steps you have taken for apprehending the accused number 2 to 5? When they are filing the cases before this court, that shows that they are very much available.
They went to the house. He's locked since 2 years. He's running electricity connection.
And how can a person who is not residing in the house can file a writ petition describing these addresses, these search? No, it is a clear case of collusion of your officers with accused. Yes. What happened to the petitioner? See, learned counsel for the petitioner contended that the respondent police with a malified intention to help the accused number 2 to 5 have not arrested them and also failed to file a counter affidavit. They filed a implead petition before this court. When they filed a implead petition before this.
Yes, they have filed the implead petition.
Therefore, you are repenting accused 2 to 5. You disclose where your whereabouts to the police. See, according to the police, you are absconding.
They have served notice and we are also posted the veterinary doctors to the SHO of the partial PS.
How can they say? Have you followed the submission of the letter counsel appearing? See, if they are violated the terms and conditions, and when you are not in a position to execute the warrant, when NPWs have been issued by the concerned magistrate court, it is your duty to execute the NPWs, and they are saying they are very much aware, and their whereabouts are known to the police, and police have issued the notices as required under section 41 CRPC, and they have also submitted the explanation. Then how can you say government Peter their house is locked, having served a notice under section 41 CRPC?
misleading and disregarding the order what you have sent.
That is a clear case of you have colluded with the accuser number 2 to 5. I will direct the CBI to inquire into the allegations, including your officers. Not by the CID. I know that what is the role of the CID. I will direct the CBI to submit a report to the court. And if the information being furnished by the CBI that at the collusion of your officers, they are not apprehended the accused, then I will impose heavy cost on the state government. And I will direct the state government, to attach all the salaries, one-day salaries of entire department, from DGP to constable. Change of officers, you want to facilitate the accused. Then, when the accused are coming before this court and accused are filing criminal petitions, accused are filing the implete petitions before this court, and they are very much aware availability to the advocates, and how can you say that they are not available and they are upstanding? That is the duty you are doing, your officers are doing, and they are not in a position to apprehend the two accused for last more than 3 years in a small offense. And you are reporting the magistrate saying that they are absconding. You are aware, you are available to the police. See the accused before this court saying that they are available, and your police says that they are absconding. I don't know. Only the issue involved in this case is very limited. Whether you are available to the police, being produced before the competent court or not is the question. And you are saying that you are available. You are residing in Hyderabad only. शाम पे बिरयानी सब खा रहे बोल के भी बोल रहे आप. ईद भी मना रहे आप, सूर कुरमा भी सब कर रहे. వాళ్ళు అన్ని చేస్తారు. Because they have not taken them to the any restaurant having biryanis. See, have you heard Mr. Leonard Goldfeder? Have you heard the arguments of the Leonard Council for the petitioner as well as the respondent counsel? Respondent saying is very much available in Hyderabad, and your people are saying that absconding. To report to me that necessary action being taken of their apprehending by the next date of hearing. List this case on 2011-2020. You inform your officers. Otherwise, I will allow the writ petition directing the investigation has to be changed, and I will impose heavy cost on your officers. Yes. Yes, the presence is dispensed with temporary presently. The presence of the officer so and so dispensed presently.
Okay.
Have you, Mr. Upender, you are in a position to explain what was transpired in the court to your officers.
There is another police officer observing the TV and the TSHC they are coming here. That's the instructed to come in the morning.
No, you instruct properly that when an accused has submitted this court that he is very much available, and how can the police will say and file a counter affidavit? It is elections ఇప్పుడు వచ్చినాయండి. ఎలక్షన్ 5 సంవత్సరాలకు ఒకసారి వస్తాయి కదా, 5 సంవత్సరాల నుంచి రోజు ఉండే కదా. Now that presence of the accused is very much necessary. Yes.
Item number 69 to 72.
Yes, Mr.
An application for grant of no objection certificate for establishing a retail outlet. The sale of the prospectus certificate. Subsequently, this order
Yes. Yes.
Director to respondent, Commissioner of Police. Initiate my application and no objection certificate for conducting sales of my petrol.
Read para 2 of the last operational portion of the orders passed by this court on 13/3/2023.
Yes. In the circumstances, the response are directed to issue NOC to the petitioner on the same terms and conditions
as described in respect of Mrs. Bharat Petroleum Corporation Limited by proceedings RC number A43745/2020. So dated 6/2.
Yes, who is appearing for the respondent police? What do you say about the?
Now that restrictions on the security was relaxed, a high power company was constituted by the government.
See, one clarification, Mr. Government. See, before even high power committee cleared the case, so far as the case relating to the Bharat Petroleum Corporation, you have granted See, when there was no high power committee, according to you, you have granted permission to the Bharat Petroleum Corporation. Now, why there is a permission is required, clearance is required from the high power committee?
Terms of reference was given to the high power company.
When high power committee was constituted?
12/4/2022.
This is with regard to 69 GO, giving clarification to 111 GO.
Yes.
That is with regard to granting exemption to the verify.
Yes. Of reference of the committee are thus whereas for potential exemption of pollution to issue reservoir.
Yes.
To suggest broad guidelines for zoning, including infrastructure of fields. To suggest modalities for development of trans infrastructure in this. To suggest various means of resources mobilization for taking up infrastructure, roads, major drains, STDs, diversion drains, etc. To suggest appropriate institution framework for taking up infrastructure, declare the development of this area. To suggest necessary agreements to be and granting any level of building permissions. So that this is to be made in existing legal framework to effectively declare the developments and managing the guidelines within the districts. Ensure that not totally focus.
I am only asking a simple question. Even before the high power committee being constituted under the GOMS number 69, see, you have granted permission of issuance of NOC to the Bharat Petroleum Corporation. This court has directed on 13/3/2023 to examine the case of the petitioner on par with the case being considered under the Bharat Petroleum. Have you taken any decision?
We have considered and rejected.
What rejected?
We have kept in abeyance.
Why you want to keep
We are
in
waiting
abeyance?
for the guidelines.
Because the petitioner has not fulfilled your material instructions. It is only like that.
We are trying to contract.
This GO has been issued by the giving a relaxations to GOMS number 111. Have you aware about the history of the GOMS number 111? No. Why the GOMS number 111 was issued? To protect the two lakes, water bodies, Himayat Sagar and Usman Sagar, for the purpose of supply of drinking water facility to Hyderabad. The constructions have not been allowed to the adjacent area, the upper areas, water flow areas, to free flow of the water to be collecting these two tanks. Now you are saying that you have taken up various programs of Mission Bhagiratha and other. There is no water problem so far as the twin cities of Hyderabad citizens are concerned. Therefore, you want to give a scope of development of the area which has been prohibited under 111 GOMS. Therefore, you issued a relaxation under GO 69. How it is having an impact over the permissions being granted for establishment of the petrol bunks? Is it only one petrol bunk in the 111 GO or there?
19 applications are pending.
No, you forget about now. There are no petrol bunks as on the date according to you. And why you have granted under which?
GO 69 we have.
No, even prior to the GO 69, you have granted the permission for establishment. Then how can you say that it has been referred under GO 69 now? It's all these things are, Mr. Rupender, absolutely mollified on the part of your administration. What HMDA can do? And every citizen of Hyderabad knows what is the role of the HMDA. Wherever open plots are available for public at large, those are for disposal purpose to are doing the real estate business, HMDA being constituted. It is known fact to everybody else. You don't have any business in HMDA. That is only the business. You are a businessman. You are not created or constituted for the purpose of welfare of the Hyderabad citizens. What collector can do that when the government has issued a GO? See, this court was issued. Why you have not filed a contempt if that is the case?
Since we filed vacate state.
What is that vacate say? It is a case. Contempt has to be initiated direct against all your authorities.
Also, not recommended.
What is the role of the additional collector? For what purpose? What is that recommendation he has to give?
Because of the land.
You pursue the contempt. You don't have any relief granted in this case, or else you file a writ petition questioning the rejection orders being issued by them. They will communicate now. Why you have not communicated? This GO is not helpful, Mr. Upendra. And why this GO has been issued, at least 4 crores people of Hyderabad, Telangana is known very much. Why this GO has been issued by your government is known to every citizen of Hyderabad. Some may say in a court, some may not say, but every citizen will say why this GO has been issued. And this GO is subject matter of the public interest litigation case before the High Court and before the Supreme Court, if I rightly remember. Therefore, I am not supposed to comment on this GO also and powers of your government issuance of such GOs. Don't think that your officers alone is aware about the GOs. Show me under the GO, you have referred so many classes which prohibits you to apply your mind to the directions issued by the court. That's all. Show me one of the ground. Not guidelines. There was a direction issued by this court directing you to consider the case on 13th, almost 1 year, 13/3/2023. What orders you have passed? No, that is not the ground. Fortunately for him to take the case for the serious review of the court under the Contempt of Court Act. How can you discriminate the petitioners having granted the permission on 6/2/2021? So when you pass an order, Commissioner of Police or the Joint Collector, without applying mind to the facts and circumstances of the case, and every citizen affected by that order has to file a writ petition before the court. Therefore, I will dispose a writ petition saying that the person who passes impugned order has not applied his mind to the facts of the case. Therefore, is not a fit to continue in exercising powers as a judicial quasi-judicial authority. Government is directed to remove him forthwith. I will make an observation. You challenge that order in a division bench. You said that you have passed an order and somebody has to question. You have to pass an order legally, applying your mind to the facts and circumstances. You would have been requested the clarification from the HMDA authorities or the district collector, saying that earlier we have considered for granting of the licenses for establishment of retail outlet from Nanakaram Guda to Chevella, from Chevella to Vattinagalapalli, from Vattinagalapalli to Shadnagar, Shahabad, Moinabad, Shamshabad, Puttur. All these are areas which have been prohibited under 311 GO, and everywhere you have granted. You have granted big constructions for establishment of statues. What pollution issue? Petrol bunk, how it is? The petrol bunk is near to our High Court. Take steps for cancellation of the license. It is such an essential commodity for survival of humankind now.
Recently, one of my friends, petrol bunk is very old tank. He was having loss every month. Then he found that there's a holes in that tank. Therefore, the entire petrol is going down.
See, you file a contempt. You pursue the contempt. And 2 things you have to do. One is you have to, these writ petitions have become infectious. I am closing these writ petitions with a liberty to question the rejection orders. Now he will communicate. He said that it is already rejected.
It happens waiting for the bail. Another thing after this is of my police only department you opened a petrol bunk, your own commissioner issues an endorsement. They just started operating the petrol bunk and they also.
You say this, you say all these things in the contempt case. This is the modified attitude on the part of the respondent commissioner. And the commissioner having allowed its own police to run a petrol bunk in a 311 GO earlier, Now he has refused to grant the permission so far as our cases are concerned, which obtained all statutory licenses. Therefore, it is clear case of contempt. Minimum botadu. Why you are bothering? You want to help the commissioner of police? You take this ground. Then what do you say?
It's all before this.
No, he says after the GO only.
The thing I want to also specifically state that only Hindustan Petroleum Corporation applications are only kept in India. The petroleum industry has been granted from 2019.
Why?
Mineral Corporation has been granted.
Why? So all are the government of India corporations only.
Standing council also here.
No, they are not. Such an allegation, there should be some nexus to the object being achieved. You have the state government and all corporations are the central government corporations. They don't, they won't get any benefit by material restrictions by granting permission to the corporations because all are the central government corporations. But only thing is it should be viewed very seriously, having granted permission to your own. If your intention is to petrol bunks has to be run by the police department alone, that is your intention, and nothing wrong in it. Public also having confidence if the petrol bunk being run by the, rather than the dealer, by the police or the state government or by the company, they can expect some genuineness, adulteration, the public. See, whenever I go, I use it to only have a petrol at outlets of company outlets. Therefore, they may have confidence. Nothing wrong in it, but you obtain permission. I will close the writ petitions. అరే ఎంతసేపు మీరు ఇద్దరు ఇన్నర్ బాగానే ఉన్నారు నేను అర్జెంట్ చేసి ఇంతసేపు ఏం చేసుకోవాలి బడే ఉన్నాను
Next week, we will collect that. Next week,
you pass an order rejecting their case, saying that after government issue, was already passed on to was abeyance to
stating that we are keeping abeyance.
You file that order question writ petition. I will dispose these writ petitions.
Keep it pending for a week.
ఇదేందా భోజనానికి పిలిచి అన్నం లేదని చెప్పినట్టు అర్ధగంట సేపు విన్న తర్వాత నువ్వు మళ్ళా 1 week పెండింగ్ పెట్టమనంటే ఏమున్నాయి. So you are entitled to question their order of keeping in abeyance by filing a separate petition. I will grant a liberty to you.
My hands are not in abeyance, but so for rejection or abeyance.
I will record the home GP statement in the court.
Next week, my lordship, I will pursue.
Yes. There is a request of land counsel for the Mr. Rupender, you have to advise your clients in proper way. Yes, they are the police role is very limited. They will act up.
Even our traffic police, everyone, except whether the additional collector has stated that.
You say in the counter because of the reason of the additional collector. Then the court will take cognizance on the additional collector. You implead the sumo to additional collector as a contemptor in the contempt case. Yes, call the next case. You want next week? Why next week? If it is not today, it will be go some other date. List these cases on 28/11/2020. Yes.
Item number 73.
Yes, who is appearing? Yes.
Police not responding with a file a counter lawsuits. Identity and police standing with file rejoin.
See, imprimatur also amounts to allowing your writ petition. What more you want? In terms of imprimatur, I will dispose the writ petition. This court directed the police to issue notice as required under section 41 AS and also follow the guidelines issued by the Supreme Court in Anesh Kumar, and also directed the police not to interfere into the civil disputes. What more you expect from this court under Article 226? Yes, what do you say, GP? Crime number? You issued a notice under section 91 CRPC. What is the complaint filed by the petitioner? Madam, you want to file a reply? You want to file a reply? Stating what? Stating what you? You are only saying file a counter. What is that you have stated in a counter affidavit? You have not gone through with the file. I will allow the police to proceed with the investigation strictly in accordance with the procedure being prescribed under 41A CRPC and Alesh Kumar guidelines. And I will direct the respondent police not to interfere with the civil disputes. And I will dispose. Why you want to file a reply? Tell me, madam, this is the reason you want to file a reply. I will consider for granting time. Senior knows, you don't know. You received instructions from your senior. Yes, the request of land council for the petition. Miss this case for filing reply on 4/12/2023.
Item number 70, Indy Pasir.
Please, Your Lordship.
Yes,
In last adjournment, my Lordship, I was directed to implead unofficial respondents, my Lordship. Implead petition is pending, my Lordship. And I may be permitted to take personal notice, my Lordship.
Implead petition is listed today.
Yes, my Lordship.
Petitioner is permitted to take out personal notice in IA number 2 of 2023 and file proof of service in the next date of hearing, before next date of hearing.
Your Lordship, till then, the interim order may be extended, my Lordship.
Interim order, no?
Police not to interfere in civil disputes.
There is no interim order, Mr. Faisuddin.
Your Lordship, within the
the interim order granted on 3/1/2023 is extended till then.
Much of this.
Is this case on 28/11?
Much of this.
Yes, Mr. Padmarao.
Item number 35, Mr. Padmarao.
Yes. Yes. Who is appearing for the petitioner? Yes, madam, you are appearing in these cases. Item 75 to 77.
I'm not, your lordships. I'm not.
Who is appearing? What is the matter? Yes, Mr. Home. What is the case of the petition in these three petitions? Petitioner is paying to hand over the case to CBI. What are the reasons? So he is only asking to CBCID. He is not asking to hand over to CBI. There is a difference between CBCID and CBCID. CBCID is your wing only. Yes, what do you say?
But investigation is in progress.
Have you filed any counter affidavit in all these cases? Petitioner is the de facto complainant.
Yes, we have not filed anything.
What are the allegations in the complaint? You are appearing for? Petitioner is not the complainant in the case. How can you say that when a complainant is not having locus? Who is having locus?
It was a dispute between the other person and myself. But this dispute, he has filed the FIR.
Any person can put set into motion the criminal law. It is not necessary that you both the criminal laws. In criminal law can set into motion by anybody. A passer of the road also is entitled to lodge a complaint with the police. And court can also sumo to take cognizance of the cases. It is criminal.
He is pending before the trial court. In fact, there was a meeting of his into the same case.
Petitioner.
Yes.
Yes. Why he is asking CBCID? Have you filed any counter affidavit? Have you filed your counter affidavit, Mr. Government? Is there any specific direction to file a counter affidavit on earlier occasion?
No. But respondent police have issued net one notices, my lord.
See, you have submitted on the, before this court on 13/2/2023 on the instructions of the station house officer, Neranbet Police Station, Rachakonda Commissionerate, that investigation will be completed within a period of 6 weeks and appropriate report will be filed under section 173 CRPC. What happened?
But notices were issued to the petitioner for the evidence, my lord. Petitioner did not turn up.
Close the complaint. Close the complaint. Why you are keeping pending unnecessarily? When there is no material available to proceed further with the investigation, close the complaint saying that lack of evidence. No, there was a direction that you have given an undertaking to this court that you will complete the investigation within 6 weeks. What are the steps you have taken in pursuance of the orders of this court dated 13/2/2023? Now we are in the almost all year ending. You have given an assurance to this court in the month of February. So your officers are escaped from the liability. The matter is not listed before this court. Now I will direct your appearance of your officers subject to their paying cost of ₹5,000 each. Get instructions by tomorrow, Monday. List these 3 cases for instructions of the governor freedom. And Monday. See what are the steps they have taken in pursuance of the assurance being given to this court. Yes, call the next cases.
Item number 38, Mr. Pullaro.
My lord, I beg to appear for respondent number 8, 10, and 12 in this matter, my lord.
Yes. Yes.
My lord,
Yes.
Yes, my lord. One of the prayer in this writ petition was non-registration of FIR against the said respondents, my lord. But presently, FIR number 824 of 23, dated 9/9/23 on the file of Banjara Hills PS has been registered, my lord.
That's different. That's different. But the petition filed to private before they one is PS Cyber FIR for actually who are the police officer in this matter. One was referred to PS Jubilees did not register so far. By welcoming the outcome of Supreme Court and
Yes. Yes, what is it?
It was a regular registration FIR is mandatory.
And in which case? Delta Kumari.
Recently, two Janet, state of Maharashtra.
Following Lalita Kumari only.
Directions to respond to take necessary action not this FIR by violating the document as well as
IA2. Issue notices. Issue notice to in IA2. The petitioner is permitted to take out first. Contempt you have filed. What is that action you are? So why you have not registered even after the complaint has been referred by the competent court?
My lord, I beg your pardon.
1 minute, 1 minute. I will hear you. Yes.
Apologies.
Is involved in 9 cases.
You forget about the petitioner's involvement. Is there any reference by the competent criminal court to register the crime or not? According to petitioner, he filed 2 private complaints. Same were referred to, one Jubilee Hills police station, another is Saifabad police station. Saifabad police acted upon the complaint and they registered a crime. So far as Jubilee Hills police station is concerned, they have not registered. Why you have not registered is the question. You answer to that question only. అలా ఫర్దర్ ఇన్స్ట్రక్షన్స్ ఏముందండి పొద్దుగాల లిస్ట్ నుంచి ఇది అన్ని ఫర్దర్ ఇన్స్ట్రక్షన్ వాయిదాలు ఇస్తే నేను ఏం చేయాలి? Jubilee Hills came a special powers under City Police Act because all VIP stays in Jubilee Hills. Special powers being conferred under the City Police Act 1348 firstly. అట్లా ఏమన్నా ఉన్నాయా?
No, there were several petitions filed by this petitioner pertaining to these cases where I need to ascertain different issues petitioner filed police officer.
Daughter of ఎవరు? భవానీ is daughter of ఎవరు? ఆమె కూడా డాక్టరేనా? What is the problem between the couple? Why you unnecessarily involving the police in a disputes between the matrimonial disputes? అరే ఇంతగానం కొట్టిండ్రు అవు బాబు. According to you on page 9, this is an injury. ఇది ఇంజురీనా? కాదది. ఎవరు? ఫాదర్ ఇన్ లానా వైఫా? దొరికిండా మీద పడి? Yes, now what do you say?
My lord, my humble submission is that, my lord, initially also several cases were filed by the petitioner, my lord.
You forget about several cases. There is a complaint being referred by the competent criminal.
My lord, that's what. Yes, presently, my lord, as I submitted, my lord, this 824 of 23 has already been registered, my lord. With regard to the specific grievance of the petitioner, an FIR has already been registered before the PS Banjara Hills, my lord. I believe, my lord, it's been registered by PS Banjara Hills because the SI of police, SHO of PS Jubilee Hills itself is arrayed as accused, my lord. That's why I believe PS Banjara Hills has already registered that FIR.
Have you seen the photographs enclosed in support of the writ petition as annexures? Please see page number 9.
My lord, sorry, page number?
Page number 9. This shows that your client is not a human being.
My lord, my client is an elderly gentleman, my lord, and the facts of the case.
Everybody knows in Andhra Pradesh your client is elderly gentleman. Who is denying about your gentlemanship, Mr. Counsel? Everybody knows, including the court also knows about your client is a gentleman. And nobody said that your client is not a gentleman. Why you are saying unnecessarily?
No, I apologize, my lord, for the usage of that term. But my lord, the facts of the case are that it is the petitioner herein who has illegally entered into the house of the respondents, my lord, with a cricket bat. And all this has been captured on a CCTV footage, and a prior FIR with regard to this offence has already been registered, my lord.
His wife is residing with you. Therefore, to take her to the matrimonial home, he came to your residence. How it
No, my lord, the couple has already been divorced, my lord. There is no relationship as of now. Initially, my lord, when Justice Vijay Sen Reddy sir was holding the home portfolio, in a similar writ, he had summoned the couple to the court also, my lord, and in his chambers, he had asked them also whether they are interested in a compromise, and the couple had refused, my lord. At least the respondent number 12 herein had refused for any sort of compromise. And subsequently, that earlier writ was dismissed by Justice Lalita Kaneganti's order.
That is different issue, the kind is
refer to yes, the page that I have.
Yes, where is that complaint? Refer to the
Page number 16.
page number
16.
yes. What are the offences alleged in this complaint?
My lord, may I make one small submission, my lord?
Yes.
My lord, the offences so levied under 824 of 2023 are sections 380, 382, 307, 167, read with 34 of IPC, my lord. So the entire grievance of the petitioner in this complaint is already covered in this 824 FIR.
That is different issue, my lord. Kind is complaint filed by the petitioner before the magistrate.
How many complaints you are entitled to file against the very same?
Exactly, my lord. On previous complaints, this honorable court on filing of a quash petition has granted stay also, my lord. And several others have been closed for mistake of fact.
Mr. Telanki, you are unnecessarily causing damage to your own client by filing number of complaints on the similar set of facts. Trial court only formally refers the complaint. Trial court only formally refers the complaint. That's all. But once the trial court has referred the complaint, it is an obligation on the part of the police to register the crime. If somebody is agreed by the order, they are entitled to question that referral complaint on the file of this court under section 482. Have you filed any of these? Have you filed?
No, my lord. I agree, my lord. But with respect to non-registration of FIR, that has already been complied, my lord. That is my humble submission.
That is different by private complaint.
Yes. What do you say about the second complaint is concerned?
Regarding the second complaint, this contract will file in the month of January.
No, when a writ petition, he has stated that he has filed two private complaints. One has been acted upon and registered, and another has been acted upon and registered. And how can you file a counter affidavit relating to one case, ignoring the other case, which has been referred by the competent court on the file of the Jubilee Police Station? But the police has to register right or wrong, and you have to challenge that registration before
my lord, I agree, my lord. I will take steps to file a criminal petition, but as of now, I just want to submit that an FIR has already been registered. That's all I want to bring to your lordship's notice, my lord.
That is second of private complaint.
Yes, my lord. Private complaint FIR is registered.
See, you are not supposed to file a second complaint on the same set of allegations.
That is different set of acts.
రెండు సార్లు కొరికిండా నీ మీద పడి ఇప్పుడేసారి కదా కొరికింది మరి రెండు కంప్లైంట్ ఎట్లా ఇస్తావు అలా సేమ్ అలిగేషన్స్
Yes, my lord.
Taken away the vehicle from the petition house. The facts are different.
కొరుకుడైతే లేదు కదా.
No, my lord, if your lordship may kindly grant a date, my lord, I'll bring this FIR on record for your lordship's perusal. Your lordship will see that the facts are exactly the same.
Page number 9.
Page number?
IA2.
So why you filed that IA? What is that IA? Tell me. See, if they violated the Supreme Court order, file a contempt saying that they have not followed the guidelines issued by the Arnesh Kumar. See, they have already registered according to their submission.
Yes.
See, according to their submission, they have already registered one complaint. Second complaint can be taken into consideration. Sir, Yellanki, second complaint should be taken into consideration as in the statement being given in first complaint.
Different set of acts.
We will consider, yes. This case on 28/11.
Tomorrow I will submit second complaint.
I have posted 28/11. Why there is no urgency? We will see that if such cases are pending, if there is any compromise among the wife and husband. Why you are not making any efforts to compromise?
We are ready to compromise.
According to you, the couple is having children.
Yes.
One daughter.
ఎందుకు ఆమె ఎందుకు ప్రాబ్లం చేస్తారు?
Ready to compromise.
Why you are coming forward for settlement of the compromise with the
My lord, the number of cases that have been filed with me, my lord, if your lordship may see my counter, I have narrated in that, my lord.
All cases can be called on to on bench, and I will close all the cases subject to your giving an undertaking that you are ready to lead happy matrimonial life.
No, we have broken the marriage, my lord. The marriage does not subsist anymore. That is the whole issue.
ఇంకా ఈ ఏజ్ ఏం చేస్తుంది ఆమె? ఎంత ఏజ్ ఉంటుంది?
My lord, I agree, my lord. I'll from the next date of hearing, I'll get instructions to this effect also if my party is interested in compromise, my lord. Other than that, I'll bring that FIR also on record.
లోక్ అదాలత్ మళ్ళీ నాణ్యత మీద పెడతావు, ఈ సూర్యుడిని వీడిని తెచ్చి నాణ్యత మీద ఎందుకు పెడతావు? ఈ సూర్యుడిని వాళ్ళ మీద తీసుకొచ్చి, నా పేరే భాస్కర్ అంటే సూర్యుడు, మళ్ళీ ఇంకో సూర్యుడిని తీసుకొచ్చి ఎందుకు పెడతాం?
I'm obliged, man.
Item? Yes. Why their presence was direct? Why they are not?
How that whether they filed charge sheet such is also filed, it is coming for issue of summons to A3 and A. They were given 41 minutes.
Is the presence of the so-and-so officers have been dispensed with? Have you filed counter affidavit?
Already filed with that counter affidavit with that press inspection.
According to you, they have complained the directions. They have apprehended the accused, the other two accused.
But they are given 41 in notice. It's only 448.
Then you are not in a position to apprehend earlier. How can you serve the 41 notice to the accused?
41 was given long back, but charge sheet was not filed against.
And 41 was given long back. Why you waited for all these days and there was no reply from the accused? What is the next course of action available to the police when there was no reply to the section 41A? And they don't have any power under the provisions of the CRPC to arrest him, a person who has not replied to the show. Then why you have not apprehended the accused?
The grievance of the is that charge sheet.
You forget about the grievance, you answer to law. Then why they have not arrested? How much delay in so far as arresting you of them? When you filed a charge sheet in first case is 2000? Now? 30-10? 23. 5 years delay, even after service of the 41. Even after, according to you, you have issued a notice of 41. I will direct the commissioner. I will direct the commissioner of police to conduct a disciplinary inquiry against the officers who are discharging the duties from that day onwards, the first charge sheet onwards, till date, for the reasons of not apprehending the arrest even after service of the. Present officer will be exonerated from the position, saying that he has been recently assumed the charges. All remaining officers are responsible. 5 years is unreasonable, Mr. Rupender.
This is only 448.
Yes, the presence of the so-and-so presence is dispensed with. Is this case? Will it be there in the usual course? Presence of the officers are dispensed with. List this case on 28 level.
The 81.
Yes. Why?
81.
Yes. Why? What is the matter? Is there any interim direction?
Yes.
I will vacate and post after 2 weeks. See, while granting an interim order, specific direction was issued a notice and directed you to take out personal notice. You have not complied for taking a personal notice. That is the reason why you are asking. Therefore, I will vacate the interim order, and as and when you want, I will post. I will give a date to list this case on 28/11/2023.
Your Lordship.
Yes, madam. Tell me.
Your Lordship, I'm sorry, Your Lordships. Item 80. I apologize, Your Lordships. I did not want to.
Yes.
Item 82, Your Lordships. We are ready for final arguments, but then there are some material documents we just received, and we are going to file it, Your Lordships. Your Lordships may grant me 1 week for 82, Your Lordships.
Yes, at the request of the letter counsel for the petitioner, list this case on 4/12/2023.
I'm deeply obliged, Your Lordships. I apologize, Your Lordships. I didn't mean to. Apologize. Grateful, Your Lordships.
take.